My lord, I pray before your lordship to file these 4 appeals without the certified copy, memorandum of appeal.
Date you have applied for the certificate copy?
Yes, my lord, yes.
What is the date of order?
10th February 2025.
Yes, leave granted.
May I be permitted to mention
Your
the
lord.
matter on mentioning upon notice money? There is a notice money.
It is for inclusion.
No, my lord. This is from a deferment of a matter is posted on 20th, my lord. There are some further development in terms of the order, my lord. I am supposed to file the reports, my lord. State is supposed to file the reports, my lord. But there is further development since yesterday the budget was laid down. So, my lord, we are praying for some more time to because there will be change in the reports, my lord.
Pardon?
There will be change in the report. It was ready, almost ready. After yesterday's budget, there is change in the report. There will be change in the report. We require some more time to. The matter is supposed to come on 20th, my lord.
So on 20th we will extend the time.
My lord, again there will be.
Oh, they are not present. No. You are appearing for state. So let it come on 20th, or we will do it on that. And probably you get some written instructions from them, from the department.
My lord, no, my lord, they have already communicated. That is why we are mentioning about notice.
Yes.
But may I be permitted for inclusion, my lord? One mandamus application, my lord.
My lord, may I have your lordship's leave, my lord. Yesterday, your lordship was kind enough to grant me leave to file an intra-court appeal Group 9 tender matter without the certified copy, my lord. I have filed it, my lord. My lord, the prayer in the writ petition might get infructuous in case, my lord, the work order is issued, my lord. Already financial bid has been opened, my lord.
On what date the writ petition was dismissed?
My lord, on 10th of February, the order was uploaded on 11th of February.
During the pendency of the writ petition, you had any interim order?
The only interim order was to the extent, my lord, that the tender will be subject to the outcome of the writ petition. That
it will come on Monday.
I'm so grateful. I'm so grateful.
Lordship, I crave leave to file a review petition without the certified copy.
Review petition, why?
Lordship,
We'll ask the department to issue the certificate copy.
Lordships has allowed the review petition, given us a chance to file a review petition. The order was passed on 14th of January.
No,
And
have you applied for a certified copy?
Yes, your lordship.
On what date?
I applied it on 12th February. This is yesterday, your lordship. This is a changed brief and.
What to do? You give the copy of that application or receipt. We'll ask them to speed up the matter.
With the kind leave of my lord, Justice Patnaik, my lord, may I humbly, my lord, mention one matter, my lord, which has been disposed of on 10th of February, my lord. There are certain slight typographical errors, my lord, in this matter, my lord. If it can appear to be mentioned tomorrow, my lord, so that my lord presiding with Honorable Justice Bhattacharya, my lord, dictated the order.
What's the typographical
My lord, at page 2, my lord, I have indicated, if my lord kindly takes page 2. My lord, the cost title, my lord, will kindly seize, my lord, Can 3 of 2024.
All right.
My lord, it's page 2. My lord, thereafter, it's at page 7.
Only the can numbers are wrong.
My lord, there's one aspect also. My lord, page 7 also, if my lord kindly sees the can numbers. My lord, thereafter, page 9, my lord, if my lord kindly sees, my lord. My lord, there's a date which has been gone down as 2024. It should be 2022, my lord. There's an order which has been passed by Aptel. My lord, thereafter, page 18, my lord.
Instead of DVC, it should be WBER.
My lord. My lord, page 18, my lord, if my lord kindly takes, my lord, paragraph 11, my lord. Can 2 and Can 4 of 2025. And after that, WBERC.
Matter has been listed under the caption to be mentioned. It is submitted by the learned advocate appearing for the Damodar Valley Corporation that there are certain inadvertent typographical mistakes in the order dated 10/2/2025, and request the same to be corrected. We find that the typographical mistakes pertain to the can numbers. Accordingly, the mistakes which have been pointed out are corrected. And this order.
Page 2, page 7, page 9, page 18, page 19. Important chapter.
What is in page 19?
My lord, page 19, my lord. Paragraph 13, my lord. Can 3 and Can 4 of 2025. These are the applications.
Paragraph 15.
My lord, in view of that particular, my lord, mentioning of the can number, my lord, the observations in paragraph 15, my lord, might not be required, my lord, because the paragraph 15 observation is basically on the Can 5-4, which we had mentioned, my lord. Only there are two
That
applications.
we can't correct. These numbers, let it remain like that. The can numbers. This order shall form part of the order dated 10/2/2023.
Deeply obliged, my lord.
Please.
My lord, item number 55, my lord, my learned colleague friend is, my lord, appearing, and he wants to mention this matter, my lord.
Item 55. Yes, please.
My lord, may I have your lordship's leave to mention?
Item 55, is it?
My lord, item 55 and 56. My lord, the third Thursday it's appearing. Matter concerns, my lord, challenge to an eco-sensitive zone notification where only the ministry is a party. Matters listed for admission. May only request, my lord, that it be had any time, my lord, next Thursday, where it might slightly
If it
above.
doesn't reach today, automatically it will come.
No, my lord, where it might, there's some urgency in the matter next Thursday,
Yes,
my
yes,
lord.
let us see. We can't jump the queue, Mr. Yogeshwaran.
Understood, my lord. It's third week, my lord. I've
There are
not, my lord.
other pressing matters. We'll see. Please call the list.
Appellate side daily list, serial number 1.
In this matter, my lord, I am appearing for the respondent university, my lord. My lord, it is the matter of 2006 matter, my lord. My lord, by way of a public interest litigation, my lord, one committee has filed one public interest litigation before this honorable court, my lord. My lord, though, my lord, in this, your lordship knows the proposition of law that, my lord, in public interest litigation, my lord, in service matter, public interest litigation does not lie. But it was, my lord, thereafter, my lord, no interim order was there. So, my lord, paper book is ready. But, my lord, from 2006 to till today, no one has taken any steps for listing of this matter or hearing of this matter. Now, my lord, the employee who are working under our university, they are on the verge of retirement. So, my lord, I am praying before your lordship for only disposal of this matter because, my lord, matter has become infructuous, my lord.
What was the prayer in the writ petition?
Prayer, my lord, setting aside the improved notification issued by the university in the year 2005, my lord. It was the initial prayer. Page 55 of the paper book, my lord.
And there was no stay.
There was no stay, my lord. It has been admitted.
And recruitment was done.
Yes, my lord. Recruitment was done, my lord, in the year 2006, my lord. And they are on the verge of retirement. Some has retired. My lord, we are not in a position to disburse the retirement.
This petition was filed in the year 2006, praying for issuance of a writ of mandamus to direct the respondents number 2 and 3 to rescind/cancel the notification dated 11/11/2005. The said notification was issued by the respondent university, wherein applications were invited to fill up the vacancies as mentioned in the enclosure to the notice from eligible candidates having requisite qualification and documents in prescribed form, which was made available in the office of the registrar of the university from 14/11/2005 to 23/11/2005. Though the writ petition was the writ petition was initially heard on 11/8/2006, and the respondent university was directed to file their affidavit in opposition within a time frame. The petitioner was also permitted to file a supplementary affidavit. Subsequently, on 17/11/2006, rule was issued in the writ petition. As could be seen from the endorsement made by the assistant registrar, the petitioner has not taken steps to file the requisites to enable notice to be sent to the respondent. Subsequently, direction was issued on 30/3/2007 to take steps to complete the service. The same was complied with and notice has been served. During the pendency of the writ petition, please, the learned advocate appearing for the respondent submitted that the notification dated 11/11/2005 was given effect to and selections were made in the year 2006. And several of the selected candidates have attained the age of superannuation and retired from service, and some of them are in the verge of retirement. As on date, the challenge to the impugn notification has become infructuous as the filling up of the vacancies has already been completed, and no steps were taken by the petitioner to move the writ petition at an earlier date. Therefore, we find no reason to keep the writ petition pending any longer. Accordingly, the same is dismissed.
I'm deeply obliged, my lord. I'm grateful, my lord.
The rule stands discharged.
Serial number 2.
Yes.
This is that matter, my lord. I'm filing the
My
12th.
lord, I am for the applicant.
My lord. This is the 12th
Petition,
interim report. Now, my lord, kindly comes to the tagged. My lord, this is with regard to 24 Parganas North. My lord, this is the clock which is running for quite some time, my lord. Kindly, that is page 86. My lord, this is the last meeting that I have held, November 2024. Kindly comes to the page 88. Minutes of the first meeting, it has been reiterated. However, since the main issue, may I just place the second paragraph and thereafter I'll come to the present scenario. The minutes of the first meeting dated 27/8/2019 and the review meeting dated such and such held in respect of 24 Parganas were taken up for discussion. Primary 3 issues were discussed in the first and second meeting. However, since the main issue which has to be addressed at the present relates to the stretch of NH 34, renumber as 14, passing through Amdanga block, falling within the district of North 24 Pargana, such and such. Background facts is been set out. In the first meeting, the superintendent of police came and said that until I have quoted that provision part of the first meeting, the superintendent of police present reacts to this query and said that till the land losers are not sure about the quantum of money which they will get, there is an apprehension of protest of land losers. Now, my lord, next part, Lordship would see page 89. Proceedings is of 2009. My lord, the acquisition proceedings. In 2017, my lord, there were awards passed by the under section 3G5 of the National Highways Act, which was challenged by the National Highways in 2017. From 2017 onwards till 2023, matter was pending. I have recorded that, my lord. Several meetings were being held, but nothing was moving. So therefore, we had requested your lordship, I had requested the learned court below to expeditiously dispose of the matter. But in 2015, my lord, kindly sees what is the quantum which was disposed of. About 700, may I just read out from the relevant part? Yes. In such circumstances, page 89, last part. In such circumstances, in the meeting dated 21/4/2022, it was jointly submitted by the district magistrate as well as the project director NHI that if the pending applications under section 34 above are heard analogously and disposed of expeditiously within the specified time, it will be beneficial for the project of four-laning aforesaid stretch of 17 such and such kilometers, for which competent authority has already disbursed 151 crores to the land losers in respect of 21 moujas. Thereafter, the present scenario. The aforesaid section 34 applications preferred by the NHI in respect of such and such challenging awards such and such have been disposed of by the learned 7th Court Barasat 24 Parganas by pronouncing judgments from 3rd June 2023 to 12th June 2023. Basically, these were all remanded back. I have annexed one of the judgments also. The judgment passed by the learned court was communicated to the district magistrate by the project director NHI by his letter dated such and had requested handing over of physical possession of the encumbrance-free land from kilometers such and such to such and such. This is 17 kilometers. After delivery of the judgment, the district administration has received several petitions for redetermination of the compensation under section 3G5 by the learned arbiter. Arbitral proceedings has been conducted by the learned arbiter, notice for arbitration such and such Total number of land losers stroke petitioners on whom notices were served was 4,989 for disposal of 101 number of arbitration cases. The arbitration hearing was conducted where huge numbers of land losers participated. The arbitral awards were passed on several dates ending on 12th October 2023. Subsequently, all the arbitral awards in respect of 21 mojas are uploaded in the district portal on 25th November 2020. This was a huge task which the civil administration did in 24 Parganas. After the award were declared, NHI had floated a retender and one agency was appointed. Kindly skip that over. In the meantime, an amount of 488 crores 91 lakhs 70,000 such and such was credited to the account of the competent authority on 30th 3 2024. In anticipation of the payment and for effective disbursement of the same, the competent authority had started holding camps for verification of the records and collecting the documents at Amdanga BDO in the month of February 2024. Such camps continued till such and such. There was a huge number of participations from the claimants in such camps. Thereafter, the parliamentary election intervened and the model code of conduct. So there were no disbursement. The disbursement of the arbitral amount started from 19/6/2024 till date. An amount of 251 crores 48 lakhs such and such has been disbursed to several verified awardees, being 10,403. Representative of the district administration stated that the entire process of disbursement would be completed by December 2024. Now the dispute starts. The project director had brought the notice of the house to the fact that EPC contractor appointed had started the clearing and grabbing works within the scope but was obstructed by persons claiming themselves to the stakeholders. Such incident was reported by the project director to the district magistrate by his letter dated such and such. Representatives of the police administration, one of the additional SP was there in the meeting, stated that there was no prior intimation and they started giving allegations. At that stage, I intervened. Page 6. At that stage, the learned special officer intervened and invited the representatives of the police administration to suggest the date and place from where the work should be started, which would be the most convenient for them. In response to this, it has been proposed by the representative of the police administration that the EPC contractor may start its work from Dhalia Mouja, being chainage number such and such, may continue till such and such Mouja. The additional SP present in the meeting has also brought it to the notice of the house that this suggestion was originally given by the district magistrate on earlier occasion. The special land acquisition officer has also agreed for selection of this area for initiation of the work, as the logic for selection of this particular area, according to him, is that the payments of landowners in this area is almost complete. And further, there is a huge chunk, that will not be chance, chunk of vested land being the erstwhile PWD land by the side of the existing alignment where the work can be started. Reacting to this, representatives of the EPC contractors has proposed 9 December as the date for initiation of the work in the aforesaid area. It is agreed that this date will be formally informed to the inspector in charge, intimated to the DM, SP, additional SP and BDO. So the additional SP had suggested that the meeting should be ended such and such. Now what happened on 9th will be appearing from page 98. Page 98. This is the letter dated 9th February addressed by the project director NHI. Kindly see what happens, what he has said. He has reiterated the first, second paragraph. Kindly comes to C. Following this decision, Lordship is at C. Following this decision, EPC contractor proposed to commence work on 9th December 2024 in Dhalia Mouja in presence of police administration and such. The commencement was mutually agreed by such and such. Meeting is quoted. Although the EPC contractor was ready in necessary manpower and machinery, with NHI presence on the site, the work could not proceed due to large-scale public agitation demanding their compensation. It is pertinent to mention here that locals also informed that a meeting was held on 6th December, that is after my meeting, in the office of BDO Amdanga, where it was decided that no work shall be commenced till entire amount has been disbursed for Dhalia Mouja. Such statements from the locals on the ground are contradictory and unwarranted in the nature. As such, no official communication has been received. Next, it is important to note that on 9th December 2024, except for NHI and NHI authority engineer, EPC contract and a small contingent 5-6 police officer, no other personnel were present at the site. Instead, IC Amdanga, who was not present at the site, sent WhatsApp messages to the undersigned to send representatives of NHI who were already present there from before. This lack of such and such broader presence impacted the such and such. As per available record, compensation of 3G amount of 221 crores with an additional amount of 488 crores, totaling to 700 crores, have already been paid. However, local residents have reported that despite several representations, they have not received their compensation, such and such. And my lord, subsequently, the work is at a standstill. Now, my lord,
one clarification.
Yes.
This 700 crores was paid to whom?
700 crores was paid to the NHAI, to the competent authority district. District has disbursed, that is, my lord, that will be kindly comes to the calculation sheet. That is also there. I have recorded in my minutes also. That calculation sheet has been given to me by the district administration.
No, but then why are the land losers saying they have not?
488 crores already disbursed.
No, it is recorded that the land losers are saying they have not.
Now, my lord, point is that land losers will never be, my lord, happy.
No. The NHA, the project director says
that
however,
persons are claiming themselves to the land losers.
However, local residents have reported that despite several representations, they have not received their compensation. That is false statement.
My lord, that is they claim on ground. What happens is that, my lord, this work which was sought to be initiated on 9th was on vested land, land which belongs to the government. The local crowd, in absence of, my lord, good presence of police, will not allow the initiation of the work even on government land. This was vested land on which they started. That was the logic.
But the state should cooperate.
My local policemen failed to control the situation because it's a wasteland, it's a government property. So state has the duty to protect the people interest. You say huge amount has been invested by the central government.
At that moment,
90% of the compensation has been disbursed. My instructions are that a week or two for the remaining 4% because of identification. And meetings have been held even at the GP level, at the ZP level, to sensitize that this work is to be started because from December it's not happening. I also had a talk with the police administration that after the work can be started, preferably after the disbursal is complete. But even otherwise,
cannot wait till that.
No, I'm coming to it.
Okay.
There are 21 Moses. We have identified at least 17 to 18 Moses where compensation has been completely disbursed. So we can start there. Your Lordship has found in the special officer's report also, meeting also, that Dhania Moza we have identified. We have also suggested that you can start from there. Once they start from there, in the meantime, compensation in the other part will be completed and they can complete the work.
The state missionary should. NHA doesn't have the wherewithal.
No, we will provide, and whenever the EPC contractor is starting the work subsequently at Dhania Moza or some other Moza as they decide, we will have the police presence, so that the contractor
but
starts.
3 and 4 police presence will not do.
No, not 3 and 4. Appropriate police presence will be there.
Let
so
them suggest a date. On that date also, I have thought that you suggested it.
Who's for the contractor?
Contractor is not a party. In the entire proceedings, there are several contractors, my lord.
So the contractor will be ready to start anytime.
Yes.
So
in fact, today also, I think the contractor is ready.
The contractor has already mobilized the resources. The only difficulty is the land, the possession of land. Now, the issue.
Secondary examination will be concluded. Any date thereafter, we'll get 1 week for the remaining disbursal also. And we'll have appropriate police.
Now, one thing that I may point out to your lordship from my experience, on the ground, when they go, everyone claims themselves as the land losers, but they are not. They are the persons who will not get any amount. They are the encroachers. And they are the stakeholders. Say, for instance, if a road is built, the shops has to be demolished. If the shop land losers, if they are, and this is civil administration and police administration. What the police administration says goes there and said in the meeting also it has been said that how would I know who is the land loser and how would I say? I said that you are not supposed to know. This has been done by the civil administration. The law is that after the amount, this is 2017 proceedings.
The district administration and the police administration of the district go to the spot.
Yes.
If let us say 50 people are objecting, they should come with their credentials to say that this was my land, this is my land document, this is my patta, I have not received.
This process is over.
Up to 30 seconds.
Second, there has been 2 arbitrations. There is section 34. There is no challenge. If this process starts, then from there will be another arbitration. This will be an unending process.
So we will fix
On
the date.
two times
Most
this
of
has
the land loser has already paid compensation, but they are the fake land loser, my lord. As per my instruction, my lord.
We will fix the date as 1st March.
1st March, yes.
But in the meantime, my lord.
Administration. Wait, sir, please hear.
Yes, sorry.
Please hear.
Yes,
1st
sorry.
March, we will fix the date. The state should ensure that sufficient police force should be deployed, plus the officers from the district administration should also be there on ground so that the work can commence.
This was done by your lordship in respect of Sadhukhali Mouja. Because of that, Baharampur bypass has opened. This was done by the previous honorable chief justices in respect of my lord Islampur bypass. They have a machinery. District police is not having that kind of force. What
Yes,
they requisition force from the battalion. From the that machinery has to be done. If they are not able to do that, then the NHI should requisition force from the central forces.
We have notice of the date, Malad. We'll make appropriate arrangement, Malad. I'll
But
speak to the client accordingly so that
kindly tells that kindly directs. If required, requisitions has to be made from the battalion.
All right. We have
Yes,
learned special officer who has been appointed in this matter, as well as the learned advocate for the petitioner and the learned senior standing counsel for the state, and the learned advocate for NHA, as well as the learned advocates for the other respondents. The learned special officer has filed a compilation containing the minutes of the meeting convened by the learned special officer at the office of the district collector of 24 Parganas. From the minutes of the meeting, it is seen that though the contractors of NHA were ready to commence the work, there were objections raised by the local people preventing the work from being commenced. And the grievance of NHA was that sufficient police force was not deployed. As a result, the work could not be commenced. Ultimately, it was decided that the work will commence on 9th December 2024. These facts have been recorded in the minutes dated 30/11/2024, signed by the learned special officer, as well as the additional district magistrate and competent authority land acquisition North 24 Parganas and the additional superintendent of police, Barasat Police District. In spite of having fixed 9th December 2024 as the date for commencement of the work, the contractor could not do so. Accordingly, the project director of NHA has addressed the district magistrate North 24 Parganas by letter dated 9/12/2024, clearly setting out the difficulties faced by them and also placing on record that compensation under section 3 capital G of the National Highways Act amounting to 211.78 crores with an additional amount of rupees 488.92 crores totaling rupees 700.70 crores has already been paid to the land losers. It appears that the persons who are now objecting to the project being implemented are encroachers and not land losers. If that be so, the district administration as well as the police administration should deal the matter with an iron hand so that the project, which is of utmost importance, of utmost public importance, is implemented. The learned senior standing counsel for the government on instruction submitted that a date may be fixed by this court and the state administration will ensure, district administration as well as the police administration will ensure that the contractors of NHA are able to commence the work, and in respect of small percentage of people, land losers, not people, to whom compensation has not been disbursed, will be disbursed in the meantime. In the light of the above, we direct that the work shall be commenced by the contractors of NHAI from 1st March 2024. The district administration shall ensure deployment of officers on ground, and they should carry with them the necessary documents with regard to the compensation which is already disbursed and other relevant details. The
on ground,
the police administration, namely the Superintendent of Police, Additional Superintendent of Police, Barasat Police District shall ensure deployment of adequate number of police personnel at the site, and ensure that the encroachers or the illegal occupants on the margin of the existing road do not object to the implementation of the project. We are informed that the project director NHA in his letter dated 9/12/2025 has stated that only at that on 9/12/2024, when the contractor was ready to commence the work, a small contingent of 5 or 6 police officers alone were deputed, and the IC of Amdanga was not present at site, but had sent a WhatsApp message to the project director to send representative of NHAI, who was already present in the site much earlier. Therefore, the project director would state that on account of lack of broader presence, it has impacted the preparedness and ability of the contractor to commence the work. On behalf of the respondent state, the learned senior standing counsel has assured the court that adequate deployment of police force will be made, and in the event adequate police force is not available in the Barasat police district, the superintendent of police or the higher police officials should requisition the adequate number of force either from the armed reserve or from the neighboring district, so that the public project should not be hampered. That apart, when compensation has already been disbursed to the land losers, and having received the compensation, they have no right to object to the implementation of the project. We are informed that the objectors are the encroachers. The respondent should realize the fact that the encroachers have no vested right, and they should be dealt with in an appropriate manner, so that the project is implemented seamlessly. Let an action taken report be filed by the district administration as well as the police administration, and on the next hearing date, the learned special officer is also at liberty to file a report as to the action taken from 1st of March 2025. List the matter.
There is one application.
List the matter on 27th March.
Kindly, there is one application CAN 3 that is with
in place of full compensation, maybe 95% compensation has been paid, because that is my instruction.
No, we have said a minimum percentage not been
paid. Manoj, may I be permitted to just highlight
one second.
Paragraph 9.
Manoj.
The bills are being sent to me.
We further direct NHA to provide logistical support.
Manoj, there is one aspect on this. Manoj, there is already an order whereby, Manoj, this issue has already been covered by the earlier bench.
No, Manoj.
Manoj, I am leaving it to my lawyers to decide the issue, but there is an already.
Why are you? You are not able to implement the project.
I understand. I bow down.
The matter appointed a special officer.
Yes, Manoj.
Special officer has convened a meeting and he is trying to help.
Yes, Manoj.
And you can't provide a car and what?
No, Manoj. I bow down, Manoj. I bow down.
We direct NHA to provide all logistical support and amenities for the travel and accommodation commensurate to the status of the special officer, who is a designated senior advocate of this court, along with his junior associates, so as to enable them to travel for inspection and to hold meetings in respect of the highways in question, which has since been renumbered as NH12, NH31D, and NH31C. Though a learned advocate for NHA submitted that this issue was covered by earlier orders, we make it clear that the above direction should be implemented by NHA, and they should bear in mind that this, by doing so, it will be in public interest to enable the contractors of NHA to seamlessly continue with the work entrusted to them.
I will ensure that, Manoj. I will
Bills
personally.
which have been raised upon me, they should disburse.
Manoj, we'll do that. Manoj, we'll do that. Manoj, we'll do that. Manoj, we'll do that.
Special officer
We'll do that,
settled,
Manoj.
settled without any queries.
Manoj, we'll do that.
And reported on the next hearing date.
Manoj, we'll do that.
27th March.
At bar I am submitting, I'll get it done, Manoj. I'll get it done.
Please, sir. Please, sir.
Manoj, I'll get. Manoj, there is one short aspect if you Lordship can consider for today, Manoj. On the last order, Manoj, this issue was with regard to district not 24 Paragonas. There is a similar issue in respect of Binaguri, which your Lordship had taken up.
Yes, that is also there in my report. I propose to hold meetings in Jalpaiguri, Alipurduar, and Murshidabad.
There is one urgency. On the last occasion, your Lordship had directed.
Which is that highway?
Malad, that is same. Kindly comes to my report and comes to Malad the Malad minutes of Jalpaiguri.
Page.
No. I'll just draw your Lordship's kind attention to that. Hold on for. I don't need that. Just bears with me for a moment.
In the last order, your Lordship had already directed the DM Jalpaiguri to file a status report.
After that, I've held a meeting. Kindly bears with me for a moment. This has been prepared yesterday, so therefore.
No, page 83, there is something. That is 2014 letter.
Oh, that is Jalpaiguri. Yes, Jalpaiguri is at page 42.
49.
42. Yes, 49 is the Binaguri bypass. Dhupguri bypass, and 42 is Binaguri bypass. 42. Now, this is why important, my lord. This will be, my lord, this is the only bottleneck which is there in respect of Bagdogra to Circuit Bench Jalpaiguri. This is the only bottleneck. It takes about 45 minutes to cross this 5.5 kilometers. Previously, when the Circuit Bench was initially, my lord, operationalized, it used to take 4 hours to reach. Thereafter, my lord, this road was built. Now it takes from Binaguri to Circuit Bench 45 minutes. But from Shiliguri town and from Bagdogra, this bottleneck 5.5 kilometers takes about 45 minutes to 1 hour to cross.
But there is some bridge being constructed there.
This is this one. This is in this scope. Binaguri bypass. Kindly, may I just read the minutes? Page 42. I have reiterated there has been substantial development since such and such. The Circuit Bench of Honorable High Court was operationalized in Jalpaiguri in the first half of 2019. In view thereof, the Honorable Division Bench, consisting of the Honorable Acting Chief Justice Vishwanath Samadhan and the Honorable Justice Arundam Mukherjee, were pleased to pass an order in the appeal on 22/2/2019. Since I am quoted the order. Since the Circuit Bench at Jalpaiguri is operationalized next month and the stretch between the Bagdogra and Jalpaiguri via Shiliguri is yet to be widened, the Transport Secretary, Government of West Bengal, requested to issue necessary directions upon the concerned project director so the widening of this particular stretch is complete at the shortest possible at the award footing. This was done.
No, this ultimately at page 43, it was recorded earlier Division Bench Chief Justice order.
Yes.
They said the pending proceedings before the district judge are in the penultimate stage. Now it is over.
This has been
concluded.
Has finished. Now, my lord, what has happened? The entire thing has now the same in respect of 24 Parganas. Now, what has happened is that I would be able to give to your lordship the latest after I hold the meeting.
See, there are two issues in this minute.
Yes.
One is Binaguri and another is
Dhupguri bypass. Dhupguri is after circuit bench. This is east-west corridor.
All right. Now you propose to hold a meeting for Binaguri
And Dhupguri. And Dhupguri. Dhupguri also will be done.
The learned advocate for NHA submitted
Murshidabad, Jalpaiguri and
other
Alipurduar.
highway, and namely the Binaguri bypass and the Dhupguri bypass are also required to be expeditiously commenced and completed. The learned special officer submitted that he has proposed to conduct meetings at Jalpaiguri, Bagdogra, and
No. I will be contemplating meetings. Murshidabad, Jalpaiguri, Alipurduar.
Conducting meetings in Murshidabad, Jalpaiguri, and Alipurduar. If the learned special officer addresses the district magistrate command for purpose of convening the meeting, immediate attention shall be given to the said letter, and the meeting should be convened at the earliest date convenient to all parties.
Yes. And my lord, one procedural direction I have noticed from 2018 onwards, if the district magistrate, because I am going to their office, it is not that they are coming. So it is least expected that the district magistrate and this SP would be present in my meeting. In the previous times, my lord, everyone was present. In Malda meeting, my lord, this was present. In Jalpaiguri, Loshu would see, district magistrate was present. They always try to, my lord,
state that in the meetings that are to be convened by the learned special officer, the district magistrate and the superintendent of police of the district should be present.
Superintendent of police or commissioner.
Or commissioner of police should be present. In the event the district magistrate or the additional superintendent of police or the commissioner of police is otherwise held up on official duty, then the additional district magistrate and the additional superintendent of police,
they will take advantage of the second line.
But this has to be given, otherwise.
Suppose they call for a review meeting.
What I do is
they will immediately adjourn the date.
Yes.
You will make all arrangements to leave.
No, I always make conferences prior going. After they suggest, I give the
district magistrate Alipurduar will cooperate.
Yes.
She's a very, very efficient.
Yes. I had a talk with her. She has been newly
cooperate.
She is newly
magistrate Jalpaiguri will
cooperate. Also, yes.
I don't know about Murshidabad, but these
Murshidabad is also.
These two district magistrates, in fact, all DMs in the state of West Bengal will cooperate.
Yes.
Like for not 24 Parganas, though in the meeting your lordship found that the ASP was present, but actually, the entire matter is being taken up and being considered by the SP herself.
They will do it. That's all.
Deeply obliged.
Next.
Obliged. I may mention for preponing after these meetings are held.
You tell us, we will.
Deeply obliged.
Serial number 3.
Item number 3, my lord, the advocate on record of the petitioner, my lord, is suffering with illness for the last 2 days.
No, why it was listed under the caption to be mentioned at your instance?
Lord, I'm not aware.
Let us see what is.
I usually do not take the point of locus, my lord, in a public interest litigation. But my lord, there is something that must be shown to the court, my lord, before your lordship takes up the matter.
No, why it is at whose instance is coming up?
Not mine.
Yeah, never will.
Then obviously must have been Mr. Chakraborty has mentioned.
No.
Who's the arguing counsel?
Arguing counsel, Mr. Chakraborty.
Yeah, I think he has mentioned.
As per his instruction, my lord, no, my lord. I don't think so.
All right, adjournment is sought for on behalf of the learned advocate appearing for the petitioner. It is not clear as to. Oh, you are only.
My lord, the affidavit has been completed, my lord.
So the learned advocate.
May I show an order of this court?
Mention the matter for early hearing today on account of he being indisposed, is unable to appear. Let the matter come under the same caption after 3 weeks. Next.
Serial number 4.
No, my lord.
You remember.
Nothing has been done. What they are doing, all bureaucratic gambling. 12 persons have died. The rest they want, the appointment would be given if you can produce domicile certificate. But I appeal to your lordship, let the NBSTC chairman appear and produce his domicile certificate. But this is the way, if the High Court's order, The poor workmen were fighting the 2014 award.
But they are addressed to the Transport Secretary on 30th January 2025. আচ্ছা
না দাওনি তো এই চিঠি দিয়ে কি হবে আমি কাজ পাচ্ছি না
কাজ পেয়ে যাবে
কবে পাবো লোকগুলো মরে যাচ্ছে তো
তার মধ্যে
না না এই তো 7 জনের জন্য বলছো
রিপোর্টটা পাঠিয়েছি একটা এদিকে
হোক আছে
No, why did we, after entire adjudication
Yes.
process, an award has been passed? You failed up to the Supreme Court.
Well, that is up to one.
Correct.
He submitted.
No, North Bengal, now you are trying to frustrate the order.
Absolutely.
We will send him directly to the correctional. We will not ask him to come here. The police will pick him up and take him there.
My lord, I appear for
This is very bad, sir. This is very, very bad. We have been giving so much of indulgence. In fact, the learned advocate general also appeared on the learned earlier occasion. Every time we have recorded. Now you say 9 members have submitted documents, 7 members are overage. Up to 65 you are employing now.
My lord, a more detailed, my lord, a report. I'm just placing lordship. Kindly have a look to this. I'm giving. I've sent the report to my learned friends also. My lord, in this report, lordship kindly come to. These are the members. Details have been given. Then lordship kindly come to the last page.
Let the employers to frustrate the order. Let the people die, then we'll come and say they have all died.
My lord, these are kindly appreciate lordship one thing. That last these pilot points which are required, my lord. Out of 22, kindly come to the my lord 5th page. Out of 22 persons, they are the claiming, my lord. 5 did not submit any document for the purpose of employment. No age proof, no educational proof, no address proof. In spite of repeated reminders, they have not sent. 5 persons have not. They are, my lord, suppressing it, number 1. Number 2, lordship, see, out of 17, they remain 17. 17 domicile certificate, very well. If they say that, lordship might be kind enough to consider. Third point, out of 15, all documents received from 9 heads. In case of 6 persons, police verification report has not come. We have repeatedly requested. That is also annexed here too. Then last minute, the 7 heads are within serviceable, are not within serviceable age of 60 years. So, lordship, kindly, my lord, give us some direction what to do. Persons who will be, my lord, who will be regularized, they are now overaged more than 60, they are not disclosing. 5 persons have not submitted any document. In
What
that
document do you want, sir?
my lord, age proof, number 1.
Where were they employed earlier?
My lord, temporary basis, they were.
Therefore, they didn't jump from somewhere. They are not sitting on tree tops.
My lord,
and
give us
jumping.
some, my lord, give some, my lord, some protection.
We will
As
issue
regards
direction.
age.
No, see, out of 22 people, 5 people did not
Anything.
submit documents. They will not submit documents. We will make an order.
Lordship, kindly do
Then
that.
it is unnecessary and it is attempt to avoid implementation of the judgment by insisting upon domicile certificate.
Yes.
Therefore, you cannot insist on domicile certificate.
Lordship, be kind enough to observe
And
that.
in respect of all the 15 people, whatever documents you have received, you have.
And age proof, lordship, kindly make some observation. If their overage is more than 60, then my lord, what will you, what will be?
2014 award.
60, that is very important, lordship.
All right.
Well,
60 years. If they have already crossed it,
will not be sent to jail. It will be done within 10 days.
it is not, because state government, the finance is not giving approval.
The national North
Finance
Bengal
approval has to wait.
Corporation
Comply with the High Court's order.
produced a tabulated statement giving details of the 22 persons who are to be regularized in service in terms of the award passed by the Labour Court as affirmed by this court. In the bottom of the tabulated statement, the following has been stated by the managing director. Next para. In our view, the above issues pointed out by the managing director is a clear attempt to avoid implementation of the judgment passed by this court, which was affirmed by the Honorable Supreme Court. Therefore, the managing director is directed to issue appointment orders to all the 22 persons in terms of the judgment of this court. The NBSTC is cannot insist upon any domicile certificate, nor any other documents, nor police verification report. And in respect of such of those persons who are stated to be aged more than 60 years, even as per the policy of the state government, the daily rated employees have been permitted to work till 62 years of age, and in some cases up to 65 years of age. Therefore, wherever there is wherever according to the NBSTC, there is a age bar, the same stands condoned by this court in this order. The managing director shall implement the order passed by this court in its letter and spirit, and give all the benefits to all the 22 persons. The compliance report be submitted before this court by filing the same in the registry after serving copy of the report on the learned advocate for the petitioner.
I have served, my lord. I have already. I have given.
No, implementation.
Implementation.
The compliance report shall be filed in the registry not later than 27/2/2025. If the compliance report is not filed on the said date, the managing director of NBSTC shall appear in person before this court on 6th March 2025.
Now, 6 persons who have died, my lord, they should be given the monetary compensation.
Would you in respect of the 6 persons who have died during the pendency of the proceedings, they should be given notional appointment, and accordingly the monetary amount payable pursuant to such notional appointment should be calculated and disbursed to the legal heirs of the deceased employee after obtaining the requisite documents from the legal heirs of the deceased employee. However, in respect of the deceased employee, the court is inclined to grant some more time, and the same can be complied with not later than 20th March.
Lordship, kindly do one thing, Lordship. Those who are asking for, Lord, the deceased employees, their particulars and one at least some intimation, they should make an approach, Lordship, to clarify, to help us also.
Submit all the necessary documents to establish their claim
Obviously.
for the NBSTC within 2 weeks from date.
Lord, some more time, 2 weeks, Lordship. Lordship, some more, no.
For that,
it's a huge task, my lord, because everything we condone. Very well, Lordship. My lord's observation, we bow down, Lordship. Give some more time, Lordship. That much I can make it pay.
20th March.
It's a process.
For deceased employees, we have fixed it at 20th March. For the other 22 people, we have fixed it at 22nd February.
Lordship, that is, Lord, some more time be given because they have not in this, age point, they have never taken up. Right now, we have sorted out now, my lord, finance is not giving approval, over aged, everything to be. My lord's order is there. But when all are within the periphery and my lord.
Wait. You instead of 27th, you change the date to 13th March.
13th March.
13th March. If they don't file the report, he should appear on 20th March in person. Then, in respect of the deceased employees, they can process it by 17th April.
Lordship, and they will make Millard applications giving all the particulars.
Within 2 weeks, they
everything will be done by this time.
No.
Yes, please.
জেলে পাঠালেই হবে, তাহলে হবে না।
কিছু হবে না।
বের করা যাবে না।
Serial number 6.
Grateful, Lordship.
Item 6.
27 March October.
Contempt. 8 BST is that?
Well, I appear for the petition. Well, this is the contempt application which was heard by your lordships that day, where there was a specific, we have served all the people concerned. Well, we had come up primarily because we were aggrieved by 2 steps taken by the padlock, the main thing. Yes, my lord. First of all, they immersed the idol, my lord, in the pond which was inside the premises, which they were not supposed to do without permission. They never took any permission. But more importantly, now what has happened is they have put their own padlock and I cannot enter my own property, and everything has come to a standstill. The property in question belongs to a deity, and my lord, Dol Purnima or Holi is coming. We have pujas to perform. I showed your lordship the photographs that day, and my lord, we are literally, my lord, kept out of our own property. When your lordship's order, your lordship has been shown on the last day, your lordship's order merely confirmed the order of the learned single judge. The order of the learned single judge is on page 238. May I just refresh your lordship's memory? Page 238. Kindly come to page 240. It appears that the respondent and its members had been possessing a portion of the property with the permission, verbal consent of the petitioner for carrying out activities like holding puja. The necessary permissions need to be taken from the petitioner, as had been held by a coordinate bench of the court earlier. It has to be taken. As a necessary corollary, it would follow that for all such activities to be undertaken by the club and its members and the said premises, permission of the owner has to be taken. It was not taken for the purposes of immersion. Since it is a property owned by a deity and there is a temple in it, the petitioner is well within his right to insist that no non-vegetarian food is consumed in and around the premises by the private respondents and their main agents. If any of the parties want to establish any other or further right in respect of the property, the same has to be done before the civil court. How, my lord, the lock comes into existence without approaching any court and in utter violation of
Now,
this
what
order.
have they done now?
They have put a padlock there and I cannot enter the temple. The deity is lodged there.
Why have you put a padlock?
No, your lordship. The thing is that since more than 20 years, there are two gates, your lordship. One is main gate that is open only during the Durga Puja, your lordship. And there is a small gate which is remained open for 365 days for doing the pujas, regular pujas at all, your lordship. We have never put any padlock. And there are two padlocks, one put by them and one put by us. Since 20 years, not today. It's not happened today, since 20 years. It is open only during Durga Puja, your lordship. After taking permission from them. After your lordship order, we lordship took permission from them and
let them show
What
the
is
permission.
your entitlement to put a lock?
but there is a civil suit pending, your lordship. That has
No,
not been.
you obtain an order from the civil court, and then you
Yes.
put a lock or
Yes.
put a wall
I'm very
or
grateful.
close the gate, do everything. All of if there is no interim order, where is the copy of the plaint?
Madam, may I, your lordship? May I like to file the affidavit in opposition, your lordship? There are many facts which has not been brought on record, your lordship.
Let them remove the lock.
No, we are not here to expand the jurisdiction or expand the order, scope of the order passed by the land. First of all, you have to establish a right over the property. The court, while disposing of the writ petition, said anything can be done only with their consent. So you obtain an order from the civil court. Sir, what is your instruction, Mr. Sen?
Lord, insofar as the disputes between the parties are concerned, 4 FIRs have been filed. Investigation in respect of all 4 have been completed. Charge sheets have been filed. Lord, I have written
You
instructions.
break open the lock.
Yes.
Police will break open the lock.
Directs, I will. But insofar as this application is concerned, the lordship sees page 383, which is the order passed by your lordship, division bench. Perhaps, Lord, there is no violation alleged by the petitioners of your lordships. Division bench order.
The single bench order is merged into it.
No,
I
they
should
have
be a lordship.
filed this.
The merger does not apply to contempt proceedings. Contempt is alleged of the order of the learned single judge. Your lordship said the learned judge was right. Any party agreed to approach a civil court. Now, one of the parties have approached a civil court. There is a civil suit pending. Now, perhaps there is no violation of your lordship's order of 23rd of September, which is at 383. Mr. Bose.
We have affirmed the direction.
Yes.
In our considered view, single bench was right in making certain observations.
Now, Lord, if Lord, I have to allege contempt, the contempt is alleged of the order passed by the learned single judge. Your lordship has not acted on any aspect of the matter.
They have already,
one way or the other, the doctrine of merger would not apply in contempt proceedings.
they have already
That's
filed a
surprise.
contempt
Why
proceeding
the
with the
police?
honorable single bench. That is pending. They have already filed a.
Well, then why is the police, my
They have
lord,
already filed a
really?
contempt
No,
proceeding.
Whatever your lordship directs.
Why don't you move? Why don't you move the contempt petition which has been filed?
My lord, if I move the contempt petition before the learned single judge, the learned single judge will say, my lord, I say this with the deepest of respect, the appeal court passed the order. So now, my lord, today your lordship,
that.
my lord,
You can clarify that.
My lord, but in the meantime, my lord, if this lock remains,
No.
I
The
am a little
problem is 4 FIRs are there. Case and counter, probably we don't know. Charge sheets
My
have
lord,
been
that
laid.
is not, my lord, with the deepest of respect. Well, I'm a little surprised with no aspersion to Mr. Sen. Well, why are the police saying that there is no contempt? It is between the court and the alleged contemner. The alleged contemner is admitting before your lordship that he has put a lock. The alleged contemner, my lord, is saying that there is a small gate and a big gate. We have put the lock. And in your lordship's query as to why the lock should not be removed and you get that permission from the city civil court, he doesn't have any answer. You ought to have approached the city court or the lower court, wherever the proceeding is pending, for permission.
Each one of the complaints, investigation has been done.
But then there are criminal cases filed against the applicant.
My lord, because
they have cut the trees, your lordship.
Cheating, forgery, illegal activities.
My lord, I am not on that. I am not on that.
Cut the trees.
Today,
my lord,
what is the contempt application number now pending before the single bench?
Single bench is contempt.
CPAN number?
That is not. Let me. I don't know.
What are the printout needs?
Well, it's as I say this on instructions today.
Yes.
Mr. Kaushik Gupta appeared for the petitioner.
That is there.
This contempt application has been filed alleging disobedience of the order dated 23/9/2024 in MAT 1801 of 2024. The learned senior standing counsel, Assistant Additional Advocate General appearing for the state, raised the point of maintainability of the contempt application on the ground that the doctrine of merger cannot be applied in the instant case as the division as as in MAT 1801 of 2024. The division bench only confirmed the order passed by the learned single bench. Further, it is submitted that the applicant has already moved the learned single bench by way of a contempt application in CPAN 1481 of 2024, in which an order was passed on 5th November 2024 at the request of the counsel appearing for the applicant to bring on record certain developments by way of a supplementary affidavit. The contempt petition was to be heard on November 26, 2024. The learned senior advocate appearing for the applicant before us submitted that if the applicant is to go before the learned single bench, in all probabilities he would be non-suited on the ground that the order passed by the learned single bench was affirmed in MAT 1801 of 2024, and therefore the remedy should be sought for before the division bench. In the facts and circumstances of the case, we find that the contempt alleged is on account of violations of certain observations / directions issued by the learned single bench. The division bench did not adjudicate or issue any further directions, but merely confirmed the order passed by the learned single bench. Therefore, we are of the view that the applicant can pursue his contempt petition in CPAN 1481 of 2024, which is pending before the Honorable Single Bench, and raise all issues before learned single bench, which shall be considered in accordance with this. With the above observation, CPAN disposed.
My lord, since there is a question of urgency involved because of the impending holy, would it be my lord's pleasure to at least add a line requesting the learned single
November
judge?
26th was the date given. I don't know whether your instructing counsel appeared. Somebody else appeared. They sought time to
It
file.
has not been appearing, I'm told. No, I'm just praying if a line could be added. If we mention the matter, the learned judge, my lord, will take up the matter expeditiously. That's the only thing which I'm saying.
So open to the applicant to mention before the learned single bench for early listing. One more paragraph. The written instruction given by the officer in charge, Haridev Police Station, to the learned government council dated 12/2/2025 is based on record, and a perusal of the same. It is seen that criminal cases are also pending, and in which charge sheets have been filed. Next.
Grateful.
Serial number 7 and 8.
But in this matter, I am appearing for the writ petitioner appellant, my lord, seeking from the review in respect of the order passed by your lordship's bench on 30th July 2024. My lord, in connection with the order dated 13th February 2024, passed by the learned single judge, the writ petitioner being the appellant filed an appeal against the CSC, and CSC also filed against the same order an appeal on a common point, that is whether the assessing officer should be the party or must be the party in the inspecting team. And the matter came up before your lordship on 30th July 2024. Matter was heard in length, and your lordship had been pleased to pass an order on the said date. Your lordship will find from the order itself at page 2 of your lordship's order, it is annexed with the application, review application. From paragraph 5, pilot. The writ petitioners as well as CSC Limited have challenged the order passed in WPA such and such on 13th February 2024. In the appeal filed by CSC Limited, the challenge is to the point as to whether the assessing officer should form part of inspecting team before exercising the power of assessment under section 26 of the Act. Learned advocate appearing for the writ petitioner appellant had placed reliance on 3 division bench judgments of this court and one judgment of the learned single judge as against one of the decisions of the division bench, namely such and such, has filed, the CSC Limited has filed appeal before the Honorable Supreme Court, and there was a conditional interim order granted on 14/12/2024, and the appeal is now pending before the Honorable Supreme Court. Now, my lord, at paragraph 8, therefore, this court has to wait the decision of the Honorable Supreme Court on the said issue. The learned advocate appearing for the appellant writ petitioner submitted that apart from that provisional assessment order itself is a nullity, as the order which was passed in the year 2004 has referred to the provision of the condition of supply, namely clause 29A, which stood repealed on and after coming into force of the Electricity Act 2003. Therefore, the second issue would be as to whether the mere reference of clause 29A of the condition of supply after coming into force of the Electricity Act 2003 would render the provisional assessment order as void of an issue has also to be considered in the appeal filed by the writ petitioner. My lord, there are also other points, my lord. The learned advocate appearing for the appellant placed reliance on the decision of the learned single judge of this court. Now, my lord, paragraph 12. Since one of the legal issues which has been raised in the appeal is now pending before the Honorable Supreme Court, it would be appropriate for this court to await the decision of the Honorable Supreme Court, since the challenge by the writ petitioner as well as CSC Limited is to the same order passed by the learned single judge. That apart, we also note that the pursuant to the order passed by the learned single bench, subject to certain conditions, the writ petitioner is now enjoying the electricity supply. In the light of the above, the appeal are admitted. Now, my lord, in respect of paragraph 12, my lord, my respectful submission is, as I have stated in the review application in the ground, the learned advocate for the writ petitioner appellant for the first time came to know about the factum of the pendency of the appeal before the Honorable Supreme Court in respect of the said point. And as a result thereof, no instruction could be obtained from the writ petitioner appellant in respect to that. Presently, my lord, the writ petitioner's instruction is not to press that particular point. Since there are other points which can be placed before this appellate court for decision, my lord. Therefore, my lord, since this honorable bench had been pleased for waiting the decision to be passed by the Honorable Supreme Court in connection thereto.
There are 2 issues to be decided, mainly, apart from other issues. If you say that you are not pressing the point which is now pending before the Supreme Court, what about the other point regarding the reference to clause 29A?
That is not subject matter of challenge before the Supreme Court.
So you don't want to...
I don't want to press this point which is pending before the Supreme Court.
It's up to him. If doesn't want to place, my lord, then we'll have to move on with the appeal, my lord. We'll have to hear the appeal.
Because they say he's a 70-year-old person and the litigation is pending since 2004.
Yes.
Yes. And my lord, subject to correction, my lord, perhaps the appeal filed by the CSC will be no more, because that is the only point they have agitated. My appeal would be heard in that event, my lord.
Now, you in this, has your client filed an affidavit to that effect? Because.
Oh, in that event.
Lord, in fact, my learned friend, Lord, cannot give a go-by to that point, Lord, because that is a point decided against us, my Lord, by the Honorable Writ Court. Lord, that was the point which was decided. Lord, my point, Lord, he cannot write it off. My point, I have to write off.
No, I am not saying.
No.
I am not praising that point which I agitated.
Then in that case, he is agreeing with the order, my Lord. Ultimately, the order was turned on this point.
No.
If your Lordship sees, my Lord,
No.
he has not challenged.
No.
There are so many other points.
If a decision has been rendered on this point, we have to test the correctness.
Yes.
My lord?
We have to test the correctness. That point went against you.
Yes.
Yes.
It
That
went
is why
against them.
Your lordship has
to. How can you give up a point which they have canvassed in the appeal? I was of the opinion it was otherwise. This you can't.
No. My lord, kindly appreciate one thing.
We can do one thing. We can. What is the stage of the matter?
Lord, it's still pending there. SLP is still pending.
Well, at that point, I am not praising. And the what my
can't do that, sir. You can't do that. It is their appeal. Then you will have to say, please allow their appeal.
No, my lord. Because
we can do one thing. We will include your appeal in the monthly list of March. Let us see by then if it is included. This review application has been filed to review the judgment and order dated 30/7/2024 in FMA 506/24, MAT 1200 of 24 and connected applications. The learned advocate for the appellant would contend that the court had admitted the appeals and noting that one of the legal issue raised in the appeal filed by CESC Limited is pending before the Honorable Supreme Court, and this court has to await the decision of the Honorable Supreme Court. The learned advocate for the review applicant submitted that the review applicant does not wish to press that point, and the appeals filed by the applicant, review applicant, may be heard and decided on merits. This concession cannot be given effect to, since the issue with regard to whether the assessing officer should form part of the inspecting team before exercising power of assessment under section 126 of the Act. 126 of the Act was decided against CESC Limited by the learned single bench, and CESC Limited have filed an appeal in MAT 1200 of 2024. Therefore, the review applicant, who is the appellant in FMA 506 of 2024, cannot make a prayer that they want to give up this point, because that point is being canvassed by CESC Limited in their appeal. Therefore, we find no grounds to review the order passed in the appeals.
Only one
dismissed. Let the appeals be included in the monthly list of April.
But your last direction, your lordship directed the appeal to be
April monthly list.
Monthly list of March.
April.
For hearing on merit, my lord.
Serial number 9.
Grateful.
I am here for the 2%.
Demand draft of this 60,000. And in favor of the names which should be given by my learned friend Prime Jia Uptrai. I have not received anything on writing. My client is here present. They have money. Once it is given immediately, I'll give it.
My lord, I have received instruction from my client, Mr. Jia. Mr. Jia is of the opinion that they are not responsible anyway for the admission of those two students. Mr. Mitropodo Ganguly has himself made them admitted in the college, and they are not anyway responsible. So no details of them are lying in our.
All right. Now, who are those students for whose certificates are withheld?
My lord, the irony is this: all the petitioners, my lord, only one certificate was issued. So far as the that is of class 10 final mark sheet. But so far as class 12 mark sheet and registration certificate is concerned, those are still with the position of the,
Then what you do is you prepare a one-page note. You give the names of all the petitioners. What certificate was given, what not given, and how many certificates are due.
Lordship, that exercise was undertaken, Lordship, and it was submitted by Mr. J. Ibrahim before this court that college authority has intimated Mr. J. Ibrahim that if these two students, they did not get the certificate. Because initially we had undertaken that particular work to return the certificate back. Only disputes raised because of these two names.
Mr. J. Ibrahim was to inform the name of the two students. If you do it, they will remit the money.
No. We are not anyway responsible.
But
for
that
the
is
admissions
a
of
statement,
two students.
contradictory statement.
No, last
Earlier
time that was
statement
what
made by him.
was submitted and we have recorded.
He was present here in this court and Mr. J. Ibrahim stated that
instructed me that he
Means
has not
stating
made
the
any
instructions
admission of those two
No,
students.
11th respondent was willing to pay 30,000 per student for two students. Mr. J. Ibrahim said that he will inform the names to the 11th respondent. At least
Subsequently, he checked his register. He has informed me that we have not made admission of those two
So then
students.
subsequent earlier statement is wrong, then how could it
at
be
least can he not give the names of those two students and the college where they study? Probably they have directly done it. Names, at least he is willing to pay the 30,000 rupees so that those two students can get the certificates and be done.
I will inform you.
It is come up in the form of an affidavit, my lord. I will also instruct my clients to depose that what are the documents they have received and what are still within the possession.
All right.
Actually, the only thing is that
All those things should also be kept on affidavit.
Regular exercise. Now this matter is coming up. My lord, I am willing to pay the money, whatever is there against me. I am facing a criminal case and I got the bail in respect of that. I'm not leaving this place. Lordship, my house, which is now locked, Lordship, let it be.
No, you are doing, you are not living there.
At least, Lordship, let me make the application
First,
before the competent
let
authority.
this happen. Let the money be remitted. We will see. In terms of the order dated 16/1/2025, Mr. Zia Ibrahim was to inform the names of the two students whose certificates have been withheld by the respective institution on the ground that the two students have to pay rupees 30,000 each. Today, the learned advocate for Mr. Zia Ibrahim submitted that he was not responsible for securing admission for those two students, and they were directly admitted by the 11th respondent. The 11th respondent does not know the names of those students. Therefore, we direct Mr. J. Ibrahim to only furnish the names of the two students and the names of the two institutions in which they underwent this course of study. Upon receiving
Within 2 days, kindly stipulate that immediately I will do it, Lordship, in that case.
If the same is furnished to the 11th respondent is directed to remit the sum of rupees 30,000 per student into the respective institutions directly, and those certificates shall be produced before and the certificates of students shall be handed over to the students, and acknowledgement be obtained by the 11th respondent. The learned counsel appearing for the petitioner is directed to prepare a tabulated chart, giving all details such as the names of the petitioners, the institution in which they underwent the course of study, the certificates, the list of certificates which they submitted at the time of admission, the list of certificates which they have been returned, and the list of certificates which are yet to be returned to them. Place the matter after 2 weeks.
Earlier only that was decided. They have submitted that the other persons they have got. That was stated.
No, my lord. I retain the same stance. One document is given in respect of everybody, and so remaining are still pending.
You ask the students to give all the data. You
in the form of an affidavit, my lord. I will, my lord.
Tabulated form.
I will, my lord. I will. Extremely grateful.
Matter will appear
after 2 weeks.
2 saptah.
Next.
Serial number 10. My application may be considered if I pay this.
Mr. Chatterjee will be here.
Otherwise,
he will not leave you.
Next.
Next.
Serial number 10.
10 minute, I beg you.
Lordship, I am appealing in person. Lordship, may I start?
Yes, please.
Lordship, actually, two allegations are involved in this writ petition. There are two types of housing estates situated in the state of West Bengal. One is RHE, that is rental housing estate, which is regulated under the West Bengal government premises Regulation of Occupancy Act 1984, and whose allotment is strictly restricted to the working government employees. Another one is public rental housing estates, that is PRAG, which has 89 housing estates throughout the state of West Bengal, out of which 4 housing estates located in Durgapur. By a notification issued by the respondent 1 on 16/10/2020, notification number 582. Before that, the respondent number 3 was the prescribed authority for PRHs, all PRHs. And as being the prescribed authority, respondent number 3, he made several bulk allotment agreements in the year 65, 66, 68 with different companies, private, government, located in Durgapur industrial area. One of which is respondent number 4, that is Messrs. Phillips Carbon Black Limited. They got 91 number of flats in Shagarbhanga PRHE and Bidhannagar PRHE. And they have allotted their employees for their accommodation purpose. Almost all agreements became revoked in the year 1988, 89, 90. Few agreements were made with few companies, one of which Phillips Carbon Black Limited, in the year 1990. And that agreement was valid up to 95. Thereafter, no agreement has been executed. When the agreement was expired in the year 95, 89 numbers of flats have been regularized in favor of the worker allottee who were in occupation at the relevant point of time. Only 2 have not been regularized. Even that 2 flats never allotted to any worker allottee, which is still being used, one in Shagarbhanga as a recreation club of their employees, and another one is located at Bidhannagar, which is operating as health center for their employees. They don't have any agreement, but so far I know, the respondent number 3 is still taking rent for these 2 flats from private respondent number 4. This is the one issue. Second issue is with respect to private respondent number 5. There is a clear order of the Honorable Justice Rajashekhar Manta on 5th October 2018 that the premises should be, that respondent number 3 should initiate section 6A. The order is in the page
23.
24.
Direction 24.
Just below, in such circumstances, this court is of the view that the writ petitioner has not been able to demonstrate any right, title, and interest in the said property in question and is continuing to reside in the said premises is in gross illegal occupation. The authorities shall be entitled to take steps in accordance with section 6A that they have not taken. And the private respondent has not any agreement. 4 has not agreement that I have obtained under application RTI.
No, the respondent number 4 is the company.
Is the company.
They entered into an agreement with the state, and they gave those 89 flats to their employees.
That has been given by the respondent number 3.
Yes.
Direct tenancy.
Direct tenancy.
For 89 numbers of flats. But 2 flats still being occupied by.
But one is a health center, one is a recreation.
Recreation place is being used.
Now, what is your prayer you want?
That should be vacated because there is no agreement.
For those 2 flats.
For those 2 flats. And another one is with respect to private respondent number 5.
Health center is an amenity which is required, sir.
That most of the employees have already been superannuated. And this is a residential flat, Lordship. How can it be? Can it be used for public for recreation for their employees? This is a public government housing state. So many people are waiting for allotment.
No, ground pleader, how you allotted
Lordship,
bulk amount of land
my lord,
to a private company?
I am, my lord, I should answer to the respectful question of the. My lord, firstly, my lord, this particular public interest litigation cannot be treated as public interest litigation. My lord, kindly, my lord, if I may respectfully invite your lordship to paragraph 1. He himself is a part of that particular complaint. It's a private interest litigation in the guise of public interest litigation.
He is one of the 89 flat owners.
That, my lord, kindly sees kindly says, all right.
I'm not
He is still a public spirited person. Paragraph 1. Kindly sees the prayer clause A to take steps to vacate the government premises being number so and so of Shagor Bhanga IHE and Bidhan Nagar IHE. Kindly sees the address, his cost title. He's from the same. So what is his interest that firstly he is after this private respondent number 5 Mamata Dhar?
He is also an allottee in respect of one of the flat.
That I am not told. But he is, how can he is very much a part of that particular complex. Now he firstly is after this Mamata Dhar, private respondent number 5, who had one series of litigation that is before the regular writ court, not pill. Now he is praying why it has not been implemented. I can't say that, why it is not implemented. If not, they should go for contempt. Secondly, he is after this Philips company, that is 4. Lordship, now, my second respectful answer to the query of this honorable court is, he wants some reply. If it is maintainable, then I am on the next question. At page 19, he preferred one RTI. Kindly see page 19. He went on doing all these things. One RTI is at page 19. What is he asking for? Kindly see copy of agreements. If renewed, to copy of agreements, provide me so and so. We have given reply at page 20. So far as query number 1 is concerned, we said no further agreement between Philip and government has been executed or renewed as on or after 1995. Reply to query number 2, no such agreement between government and Philips at Shagordigi. So we have given, again he comes up. Kindly sees, again he comes up at page 26. September 25th to the SDO. Since from 2020, the authority is SDO, not the estate manager. So the earlier reply was my estate manager. He was given the reply. Now he is nagging the SDO. The moment he saw page 25 that we have changed the authority, he is making query to the SDO at page 26. 25th September 24. We have given reply. Kindly see page 30. Reply to page 26 is at page 30. With reference to your representation 25th September, it is here informed against the query number 1, there is no related documents available in this office. Against query number 2, there is no such report is available. If you are not happy with this reply, if you are not happy with this reply, you go for first appeal, second appeal provided for in the RTI Act.
Lordship, on 25th September,
RTI Act
that was not the RTI.
No, before that, are you a resident of the same housing complex?
Yes, I am LI. I am in LIG. I am an authorized LOT.
Then there is a tinge of personal interest there.
No, I don't have any interest.
No, in your representation, you say some political affiliation of the.
Yes, that is being used. That flat is being still being used as a political party of it.
There is already an order passed by the single bench.
That has not been complied.
We are not an executing court. We are not an executing court. That too at the instance of a resident who is there. You have got a personal interest in the matter. You have got an axe to grind. You don't like your neighbor. It is rather surprising for me that 79, 80 flats, bulk flats, you gave it to a private limited company.
No, but it says that there is no such as on date. The first reply.
Initially that expired. As on date, it is not there. They are a blue chip company, sir. Why should you be giving government accommodation to them? People are without accommodation. All our staff employees are coming 60 kilometers, 70 kilometers every day. But there is no place for If you have to work in the protocol department of the High Court, you should reside within a radius of 3 or 4 kilometers. There is a restriction. We are compelled to relax it because nobody, affordable accommodation is not there. And what is the state doing? Giving it to a blue chip company as if those fellows, employees don't have the wherewithal to buy property or to rent out property. That is against public interest. We need to comment upon that. Then you should have put it for auction. Bulk 90 flats, 80 flats to and the worst thing is you regularize their occupation of the individuals who have, according to them, attained age of superannuation. This is all something under the table.
Milord, that part of the grievance, Milord, I
discharge him. We will probe under what circumstances Phillips got the allotment of these 98 flats or 89 flats.
Regarding that aspect of the matter, Milord, the SDO may have to throw some light on it.
That's a very, very serious issue.
So, Milord, let the SDO throw some light on that.
Where were you employed?
I'm not employed.
You're in business. What are you doing?
I'm some supply business.
I am appearing for the private respondent.
Just now, the SDO has sent some online instruction.
Please read. Please read.
Lordship. All the Lordship, let me read from my mobile, Lordship. There are 3 public rental housing estates within the local limits of Durgapur subdivision. Sagorbhanga, IHG, and LIG having 1994 flats. Bidhannagar, IHG having 1260 flats. And IHG having 150 flats. All those housing estates were under the control of estate manager and ex officio so and so till the notification of 16th October 2020. Long before, so many companies had the agreement with the housing department for their employees. Presently, as many such companies had been closed, the allottees are now under direct payment mode within the department. As per record available, it is learned that some of the flats may be occupied without proper legal rights. Within bracket, though staying with families very long, bracket closed, needs proper verification. Again bracket, which needs time and other administrative resources. The petitioner also got an allotment at quarter number L65 at Sagorbhanga Housing Estate from department in January 2021. Under the present socio-economic scenario, any harsh steps from the local office may fuel unrest amongst the unauthorized occupants. Matter in which regarding writ petitioner has filed has already been discussed, and an execution policy has been started, rolling by identification of up-to-date rent, legal paper availability, inheritance applicability through legal heir, etc. The undersigned, only 4 lines left, my lord. The undersigned being SDO Durgapur being appointed as competent authority recently, praying for time to finalize the legality of all existing 3404 flats. As the waiting list is properly kept at our office, so whenever it will be completed, the deserving applicants, as per the norms, according to the serial, will get their allotment. However, the representation of the application will be hard, subject to leave of the Honorable High Court.
Those waitlisted people for their lifetime, they will not get. They will not get. This is in Durgapur.
Durgapur, Lordship.
In and around here, Kolkata also you got flats? Same scheme?
Yes, there are. There are
38 housing states in Kolkata Municipal Corporation area.
150 flats you allot for the High Court employees. We'll pass a direction. He has flagged the issue. Until then, these fellows, these officers are acting hand in glove with the illegal occupiers. First of all, in my opinion, subject to what you may say on record by way of an affidavit, the allotment in favor of Philips, a company, a limited company, itself is illegal. It does not serve public interest. The schemes were floated for certain other purposes. They are not low-paid employees. They are not government servants. On their own volition, they went and joined the company. Probably you will take a stand, if in all probabilities, that there were no takers. These people came in, we gave them. Well and good. After the agreement is over, you should have thrown all of them out and made the flats available for public, for employees. This is illegal, sir.
Lordship,
how did you come into possession of the property?
May I indicate? When we were operating the factory, under the Factories Act, the workers, when the state government provided for these homes, hence the state
Factories Act does not.
It was the workers were in part when the state government, when I was operating in manufacturing unit, so the workers, with the stay of the workers, I had approached the government, and then the government was there. Thereafter, initially, whatever is the allotment, I am now at present, is only few flats which are under me where the workers are.
Lordship, I've got the printed. Lordship.
The fact is, I understand what is troubling your lordship is that this is entirely is a public premises and it should not be used to the proportion. But what is to be sought to be differentiated in my case is that my agreement should expire where I had applied for renewal. Because your lordship knows this.
You did not apply for it.
I applied for renewal. It's a government premises undertaking. Any eviction has to be done in the mechanism. I'm not on that. I applied for renewal. My name change was taken on record. I had paid rentals up to date. My renewal is pending. Till January 2025, my payments have been received by them. So it is not a case of the writ petitioner. Maybe writ petitioner is flagging a social cause, trying to affect everything. But in my case, I would say, without getting into the maintainability, I would say by virtue of the principle of the holding over, when my workers are there who are aiding to the state and they are deciding in the premise.
No, the instruction is otherwise by the sub-divisional officer.
Your lordship, I do not have the notification, but I can put it on an affidavit till January 2025. I have paid rents. It has been accepted. The government recognized the change of my name should change. All this I can put this on affidavit. At least vis-a-vis my premises, there is no proceeding under section 6 that my tenancy has been terminated.
No, you are speaking about 89 flats or?
I am 89 out of 89, 87 has been surrendered.
We are on that. We are on at the inception. How were you entitled to 89 flats, being a company registered under the company, operating for profit?
By virtue of the leave and license agreement I entered into, I can put this in affidavit.
You need to.
I need to.
And then we will haul up the government as to how it is. People are suffering, sir. And you are a blue chip company and all white collared employees are there.
Not white collared. All the workers were fine.
All right. What is obviously you will be paying above the minimum wages.
I am.
And we have got Badli workers here who are being paid about 6,000 rupees per month.
I bow down to that. But my endeavor.
Sorry, state of affairs, sir.
My endeavor.
After working for 24 years, that fellow's take home is 32,000.
It's very sorry, state of
affairs. And on the attaining age of 62, 2 lakh rupees or 3 lakh rupees is given, which is also not disbursed. No, but this is
my endeavor will be only to demonstrate, your lordship, that I have done my obligations in due process of law.
Sir, the government may give you some concession. Government may give you some incentive. They may give you subsidy in power, subsidy in respect of land. That is all different.
Yes.
How can the public largesse be distributed like this in bulk to a company which is operating for profit. So Philips
Lordship.
Carbon Black Limited does not do any work or anything in public interest. It is a profit-making organization.
Lordship, if I may respectfully, my lord, apprise the Lordship the reply which was given by the state manager on 23rd December 2019 at page, my lord, 20. It says on or after 1995, there is no such agreement subsisting. So, my lord, may I, my lord, suggest, my lord, subject to your Lordship's correction.
So, if the inception is wrong, your regularization of 87 flats is wrong.
As on
And
date,
as on date, the SDO does not know whether he was an erstwhile employee of Philips Carbon Black or somebody else is inducted inside.
so therefore, my lord, if my lord, there is a
Nothing new, sir. It is nothing new.
No,
Everywhere
Lordship.
government quarters are being sublet.
Lordship. The Lordship, so Lordship, these flats, my lord, are governed by, my lord, West Bengal Government Premises
Please,
Tenancy Regulation Act.
file your affidavit, let us see. By this public interest litigation, the petitioner appearing in person seeks for certain directions concerning the allotment of flats which are government flats in favor of a private favor of the second respondent. Fourth respondent, which is a limited company under the name and style Messrs. Philips Carbon Black Limited. It appears from the facts placed before this court that a bulk allotment of 89 flats was given in favor of the fourth respondent company by the third respondent department, and out of which 87 flats are said to have been surrendered by the company, and only 2 flats are in possession of the company for which rents are stated to have been paid up to date. The learned government counsel questions the locus standi of the petitioner, stating that he is a resident of the said housing scheme. However, we find, from the written instruction given by the subdivisional officer Durgapur, dated 13/2/2025, we find that the petitioner has got an allotment of quarter number L65 at Sagarbanga Housing Estate from the department based on his application made by him, and the allotment was made in January 2021. Therefore, in our view, the petitioner would have locus standi to maintain the writ petition. However, one of the prayers sought for by the writ petitioner is as against a private respondent, namely fifth respondent. The fifth respondent had approached this court by filing a writ petition against writ petition in WP 25225 of within bracket W of 2014, claiming that she is in occupation of a flat number D11, 325 of Sagarbanga Housing Scheme, Durgapur, and she claims that her brother died in the year 2009, and after his demise, she continued to occupy the property. The learned single bench has disposed of the writ petition with certain directions, and while doing so has observed that the said writ petitioner, Mamta Dar, has not been able to demonstrate any right, title, and interest in the said property. So far as the prayer sought for against the fifth respondent is concerned, this court cannot act as an executing court to execute the order and direction passed in the writ petition filed by her. Therefore, the prayer sought for against the fifth respondent stands dismissed, and all pleadings.
Only one thing, I was not a party.
As against the fifth respondent.
I was not a party in that.
We are the fifth respondent.
Agreed. Fifth respondent in that writ petition, what is trying to enforce by executing that orders. I was not a party in that. The Philips Carbon Black was not.
We have not said anything, sir. And all pleadings concerning the fifth respondent in the writ petition stands struck off. After elaborately hearing the learned advocates for the parties as well as the learned advocate appearing for the fourth respondent company, the court is surprised to note that the note that a bulk allotment of 89 flats was given to the fourth respondent, which is a limited company carrying on business for profit. Admittedly, a housing scheme is floated by the government to provide affordable housing to the general public. And when public largesse are distributed, it should be done in a fair and transparent manner. Therefore, we are required to consider and probe into the matter as to how bulk allotment could have been made in favor of the fourth respondent company. This has to be decided after affidavits are filed by the concerned authorities and more particularly at the level of the Principal Secretary, Housing Department. The Subdivisional Officer Durgapur, in his written instruction dated 13/2/2025, has stated that the matter which has been flagged by the writ petitioner has been discussed and an execution policy has started rolling. It is not clear as to why the authority did not do anything earlier and has had to wait till the writ petitioner had flagged the issue. If a person who does not have a valid right to occupy a government premises, then the authority, without anybody informing them, on their own accord should have taken action. Therefore, it is a clear case of failure of state machinery to protect public assets and public property. Therefore, we direct an affidavit to be filed by the first respondent covering all aspects of the matter, as well as separate affidavits by the respondents 2, 3, and 4. Giving 2, 3, and 4. In the affidavits to be filed by the official respondents, namely 1 to 3, full details of all the allotments right from the inception and the names and details of the present occupants, etc., should be furnished. To be noted that the affidavit should be comprehensive and should contain all details in full. List the matter on so and so.
Lordship, few correction. Total 91 flats were allocated, out of which 89 have been regularized.
91. Next.
Returnable, Lordship, regretful.
We'll give some sufficient time.
Lordship.
Serial number 11.
Sir, one more, sorry, sir. The court can take judicial notice of the fact that several of the High Court staff and employees do not have affordable housing accommodation in and around Calcutta, and they are compelled to travel long distances from faraway places, and whenever trains are cancelled, the employees and staff, including the officers, are unable to report on time or report to work on time. The Principal Secretary, Housing Department, is directed to file a separate affidavit indicating the vacancy position of flats, government flats, in Kolkata, and upon receiving the details, the court will consider as to whether any direction should be issued to earmark a particular number of flats for the officers, staff, and employees of the High Court administration. There have been instances where in other states, there are instances which is known to one of us, within bracket, put my name, where the government has constructed houses either by the Housing Board or by the Public Works Department, and a percentage of flats have been allotted to the officers, staff, and employees of the High Court.
Sure. On a lighter note, I'll be more.
We fought for it. We have got 7 blocks, each block of 12 floors. You should see the amenities on stilt plus 12 floors, covered car parking. If there is a will, there is a way, sir.
On a lighter note, Your Lordship, I would like to champion this cause, my recommendation.
Which one?
The cause Your Lordship just mentioned in the order.
Ah, yes, sir, we need to do. They are suffering.
Even in the district.
Of course, they may have a small piece of land, an ancestral property. They would have constructed about 400, 500 square feet in that and living in small areas. Now, because of that electrification projects, some 29 trains were cancelled. You ask Uday? Last month. Still, I think it is not resumed fully. And most of them are either from Chandranagar, Vaidyavadi, or beyond that.
We know, Lordship.
And they can never take a bus. If they take a bus, they will reach only at 4 p.m.
Launch is the
They
only
have to
way.
come by train, then catch the launch. All these launches are all overloaded.
Even the basic amenities like washrooms are not being still in our coach. That's not there.
Anyway, sir, Bengal means business.
Lordship.
Serial number 11. My lord, I am for the petitioner.
Beg to my lord, appear for
Service.
the state respondent, my lord.
My lord, this public litigation application was filed for the demand of stop of any kind of recreational activities in the playground. And the scheduled property in this application is now using for commercial activities throughout the year. My lord, it is completely a playground. The donors, the play lovers, and the guardians all are the petitioner of this case. And these donors of this playground, they are very much worried. Many times they have already shown their grievance against the authority concerned. My lord, regarding commercialization of this playground, the petitioner have not annexed
These are all permanent shops, is it?
permanent. This is under the district inspector of school, secondary.
It is a property of school.
School property. But
See the photographs.
Yes.
In page.
That's the thing, but there is a extent government order in this respect, my lord. My lord, may I just place this memorandum whereby, my lord, whereby, my lord,
My lord,
that
before-
any
before-
property which or in building or infrastructure which belong to school cannot be used for any other purpose than the education, except with the previous permission of the government, means the school education department, not even the DI.
My lord,
So in this case,
my lord, before moving this application, my humble prayer, my lord, I have not annexed few papers of evidence
Wait.
regarding.
One
May I-
second.
may I
Please
read out?
give us 1 minute time.
my lord. একটা আছে দেখছি। তিনটে আছে।
No. Who has made a request for this football tournament?
Yes, here the petitioner is claiming this, that this has been used for other purpose. But here, my lord, of my instruction, the second page is in Bengali vernacular. He is addressing this to the school authority for using this on 30th of November 24 for 8-team knockout football tournament.
All football
One way he is raising
All right,
objection.
we'll throw him out. We'll throw him
Now,
out. No problem.
yes,
But
that
you
is
come
the
to
fact.
photographs. There
Yes.
is some mela being
Yes,
conducted.
that's the thing, my lord. Without the permission of the school cannot give such permission, since it is now it is a government, the school's property, government sponsored school.
Ask them to dismantle the mela.
My
is
lord,
over. Ask
yes,
them
the
to
school
dismantle.
school is answerable.
Not only that.
What they say is about your locus standi. You wanted to conduct a football tournament. They rejected your application. Therefore, you have filed this report.
Now,
not only that,
being a donor, once
the mass-
donated,
kindly consider the mass representation. That is
Once-
not limited with this.
once donated, then cannot claim now to monitor over the property of the school.
You become the guardian.
Yes, the
You become
government.
the trustee.
Yes.
You become the trustee.
Absolutely, my lord.
So what is the role of a trustee? If there is a breach of trust,
Yes.
you have to go behind bars.
Yes. That is the fact that if the school,
So your responsibility becomes much higher than the responsibility of the donor.
yes.
You need to discharge your duties in public interest.
Yes.
If you keep on giving these playgrounds for fairs, melas, this, that, etc., private marriages.
No. That the school is answerable for that. Without our any government's permission, if school has allowed, they are answerable
Who
to that.
appears for the school?
Yes. School.
School is not present here, but I have already
sir.
I have soft copy, Milord.
The,
I've already
the issue in this writ petition is whether a land which has been earmarked as a playground for the school, which was donated by certain well-wishers, could be regularly used for the purposes of conducting fairs, melas, etc. The petitioner has annexed photographs along with the writ petition, which shows that there are several sheds which are, virtually appear to be permanent establishments. The learned advocate appearing for the state submitted that in terms of the notification issued by the Commissioner of School Education dated 18/12/2018, there is a clear bar for using of school infrastructure and premises for non-educational purposes unless and until prior permission is granted by the school education department. It appears that the petitioner had filed an application for conducting of a football tournament, which was negative by the authorities. It is not clear as to on what ground it was negative. In any event, football being a sport, the authorities could have considered it. However, this may not be a ground to reject the public interest litigation, since there are other persons who have signed the mass petition and who have also, and some of whom are also writ petitioners. Therefore, the objection regarding the locus standi of the petitioner stands overruled. Considering the seriousness of the issue, since we are inclined to dispose of the writ petition without calling for affidavits, and more particularly when the persons who have organized the fair/mela are not been implemented, we direct the district magistrate Purva Medinipur to immediately send a set of officers to conduct an inspection of the area and examine as to whether any permission has been granted by the competent authority for conduct of commercial activity in a playground, and if no such permission has been obtained, then appropriate instructions be given to all the authorities, including the district inspector of schools, Purva Medinipur, Tamluk, to direct the removal of all the sheds, shandies put up for conducting mela, trade fair, etc., and ensure that the property of the school is not used for any non-educational purposes unless and until the appropriate authority grants permission, bearing in mind the public interest involved with regard to the said application. The above direction.
Milord, on correction, Milord.
Within a 3
Milord, one small correction. District inspector of school, secondary.
Secondary.
Milord.
Secondary education.
Milord, one humble prayer, Milord. My all petitioners are relying upon apex court order of Supreme Court and Madhya Pradesh High Court, and kindly allow me for submission. And
My lord is already allowed.
Other than sports activities should be banned on playground, Milord, according to the National Sports Authority and the rules and policy guided by the Government of India. my lord, the relevant point in the matter of Krishanlal versus State of Haryana is page number 5, point number 14, page number 7, point number 17. And in the matter of Surendra Yadav versus State of Madhya Pradesh, it has been clearly stated in the last line, my lord.
Learned advocate for the writ petitioner placed reliance on the decision of the Honorable Supreme Court in Krishna Lal Gera versus State of Haryana, 2011, AAR 2011 SC 2970. In the said decision, the Honorable Supreme Court has held that sports complexes cannot be converted into a recreational area. Now, stadium complexes cannot be used for non-sporting recreational activities or for holding marriages or other functions, etc. Reliance is also placed on the decision of the High Court of Madhya Pradesh in Surendra Yadav versus State of Madhya Pradesh, WP number 10687 of 2009 within bracket PIL. Wherein direction was issued to the authorities not to lease out the land for any activity which is not related to sports. Then this direction. The above direction be complied with within 6 weeks. We'll stop with this. We'll come back. This bench will.
Grateful, my lord. Grateful.
Item number 12.
Well, my lord, the grievance of the petitioner is that, my lord, it's that there are certain water bodies which are being filled up or has been filled up. My lord, your lordship's order is at page 91. If your lordship kindly takes up your lordship's last order, my lord, it is at page 91.
Yes.
My lord, although the petitioner was not represented on that day, my lord, your lordship gave the petitioner liberty, my lord, to approach the concerned department of secretary municipal affairs. My lord, thereafter, my lord, at page 93, 97 and 101, we have made 3 representations to the, my lord, 93, my lord, if your lordship
Have
kindly.
you given the details?
Yes, I have given the details in the representation. My lord, kindly takes up
Page 98.
Yes.
Tag number 416.
Yes. Well, there are 3 municipalities. With these water bodies are under 3 municipalities: Domdom, North Domdom, South Domdom. So I have given 3 representations. Each and every representation contains the water bodies of each and every municipalities. Well, these 3 representations are pending consideration.
What is your instructions?
Lord, I am appearing for North Domdom municipality. Lord, your lordship has seen that in an almost an identical matter, my lords were pleased to pass this order. Now, my lord, they have appeared to have represented before the authority concerned as directed by your lordship, but without any details.
No, in the present 3 representations.
My lord, kindly, who has filled the water body?
He has given the dark number.
Dark numbers have been given, but who are the owners of the property? They are not made parties.
No, you can make.
And it is for the, in fact, my lord, it is for the state to submit. Lord, the direction is upon the state.
We have already given notice to all the municipalities, please supply us the details and detailed inquiry. But we have not yet received any.
We will direct them to conduct the inquiry.
But this litigant people, he has more than 150 petitions before this one.
My lord, I am sorry to say, although out of context, my lord, it is that writ petitioner where my lords were pleased to impose a cost of 50,000 against this particular petitioner. And my lord, Honorable Justice Amrita Sinha in the matter awarded a cost of 25,000. My lord was pleased to hold.
Imposed upon the municipality also. Kindly.
No.
This is not.
What is the? Is he employed or is he doing some business? What?
Social activist.
Self-employed social activist, my lord. There are various matters.
Social activists is an employment.
Every day, my lord, we find him roaming around the High Court. Each and every day.
He is there in the courtroom today.
No, right now. He must be outside the courtroom.
He is there.
And kindly see
the
paragraph 2.
He is there. He is there.
He was here. Kindly see the paragraph number 2, his description. The petitioner has been highlighting various social issues from time to time, for which many government bodies do not like.
I can present, my lord, certain judgments, my lord, passed in his favor, my lord, which will help the state, my lord, state exchequer. My lord, there are various matters, my lord, regarding sand mining, regarding the police vehicles. My lord, he has filed certain writ petitions which are.
But why his writ petition was dismissed with cost?
Only on these grounds. Lord, I was there in that matter. Only on this issue.
My lord, appeals are pending from those writ petitions.
Not in this matter, but the issue can be considered this judgment of the single bench, where the honorable single bench says the petitioner's ploy of the obtaining
Yes.
the RTI Act and then extract money from
Exactly. That was the observation of Justice Sinha.
Section 61 and debar the petitioner from filing any.
My lord, I tell you, lordship, my lord. My lord, proceedings, my lord, were directed, my lord, by the Honorable Justice Amrita Sinha against me. My lord, nothing was fine. My lord, these allegations were not substantiated.
That means
These are all.
But there is a finding saying that.
Yes.
Thereafter,
That,
proceedings.
And that too on inquiry, my lord, directing the local police authorities on inquiry, this finding was made by Justice Sinha.
Thereafter, proceedings was initiated, but nothing substantiated. These
All right.
allegations are from the
Public
bar.
interest litigation, this writ petition has been filed.
In the monthly combined list.
Monthly
By
combined.
him.
Yes, before this bench.
Kindly consider the merits of the writ petition.
All right, claims to be a public spirited person. But it is a matter of fact, it is an undisputed fact that the petitioner is a habitual litigant and has filed more than 195 cases before this court. And and the division bench also had an occasion to deal with one of his matters, and the same was dismissed with cost of rupees 50,000. In another writ petition, in WPA 3116 of 2022, the court dismissed the writ petition filed by the very same petitioner by order dated 22/9/2022, imposing a cost of rupees 25,000. After taking note of the submission that the petitioner is in the habit of filing writ petitions one after other, to put pressure upon private parties and to extract money from them, and that the writ petitions have been filed with vested interest for his personal gain. The petitioner on an earlier occasion came up with an identical prayer in WPA 5961 of 2020, which was considered 2020. In the said case, the petitioner did not appear. The learned advocates for the municipal corporations appeared, and they filed a report in the form of an affidavit denying all the allegations. However, since the petitioner did not appear, the division bench, while disposing of the writ petition, left it open for the petitioner to approach the secretary to the Government of West Bengal, Urban Development Department, and Municipal Affairs Department, Government of West Bengal, by way of appropriate representation. The petitioner stated to have given representations on 19/8/2024 to the Secretary, Urban Development and Municipal Affairs Department, and has come forward with this writ petition. As rightly pointed out by the learned advocate appearing by the respondent municipality, the person who is said to have put up the illegal construction or encroached upon a border body has not been mentioned, nor has he been made a party.
Yes.
In any event, the petitioner appears to be a busybody, and it is stated that as many as 50 writ petitions filed by the very same petitioner are pending before this court and included in the monthly list. Thus, the court is not satisfied with the bona fides of the writ petitioner and therefore not inclined to grant any relief in this writ petition. According same is dismissed. Next.
Serial number 13.
13, I am for the petitioner, my lord. This is a case, my lord. A huge this is a case, my lord. The corruption in the tender process committed by the Panchayat, a particular Panchayat Pradhan, my lord. My lord, Lordship will kindly see how the corruption has been made. My lord, page 31 is the, my lord, NIT, my lord, which was issued on 4/12/2023, my lord. The serial number 1, my lord, the seeding Mark 2 tube well near the Uttar Rampur Horipara Govindo Mandir at the Uttar Rampur under the Kushida GP, Gram Panchayat. My lord, the next page is the representation, my lord, which I made made of the local residents to the, my lord, concerned authorities, and my lord, the seeding tank, my lord, is the 2-cylinder. My lord, what is happened, my lord, page 34 is the photograph, my lord, where your lordship will find the single normal tube well has been, my lord, installed, and the, my lord, the next page, my lord, is page my lord 35, where your lordship with 50,000 withdrawn by the instance of the Panchayat Pradhan with the help of the, my lord, of the local contractor. My lord, the entire tender process, my lord, they have been manipulated even the my lord, the contractor has been my lord, credential has been forged, everything has been done, my lord, since the representation has been made there, my lord, since the representation has been made by the my lord, local my lord, the entire online procedure is available, but they have done the offline my lord, tender has been issued, and there, my lord, the thereafter lordship will kindly see the page 45 lordship. This was the my lord, one my lord, the drain covered drain my lord, to install from the one place to another place. There that drain has not been covered and 5 meter has been cut, and this amount also been withdrawn by the my lord, contractors. Thereafter, my lord, the Upoprodan and the rest of the my lord, uh, my lord, members who has
Your allegation appears to be very vague. You say that credentials are forged, etc. What is the eligibility criteria? How the private respondent is not eligible? You should have obtained information under the RTA Act, and then you should have done
my lord,
some
the
research.
apparent face of record, lordship will find the my lord,
Contractor, you have not implemented him as a party. According to you,
my lord, we have made the
forged credentials were used to obtain the work order in collusion with the Pradhan of the Panchayat.
my lord.
So you should say that the ex-contractor or respondent number so and so, he is not registered, he doesn't qualify. Therefore, in spite of that, the Pradhan manipulated the documents and gave the contract to him. That should be your. What if
Lordship, there is a public representation is there, my lord.
But can direct the video to
Lordship,
to take, consider his representation, subject to, the possibility of this being a private interest litigation be ruled out. Because one document, usually the police reports do not help in a public interest litigation, your lordship knows, but I find possibly an FIR lodged against the petitioner herein that he has beaten up the Pradhan's brother on 25th of
My lord, after my lord,
April 2024.
After made the representation from the my lord.
The petition comes immediately after that, after 6 months of that. So, will it possibly, this is something which has troubled me from
17th, my lord, I was, my lord, leading to the, my lord, to lodge the complaint to the concerned department, my lord. And 17/9/2024, my lord, this representation was done by our instance, my lord. Thereafter, my lord, the Pradhans and the my lord, hooligans, my lord, attacked me. This is the my lord, scenario. But my lord, there is something, my lord, which has happened in the corruption process, my lord, offline tender, my lord, that has to be my lord, inquired into, my lord, to the particular department.
To be a businessman. Well, I don't have an objection if your lordship directs the video, but my lord will kindly rule out that it is not a private interest.
But did you not lodge a police complaint?
But he has also lodged, my lord. He has also lodged.
My lord, that was done, my lord, 19 September 2000, 17 September 2000, after made the representation, my lord, which I have initiated the complaint to the concerned department, my lord. At the, my lord, I was the, my lord, operating everything. So, my lord, they are written up, my lord. It is a jurisdiction under Harishchandrapur police station, my lord. Each and enter the, my lord, there is a
relationship with the Pradhan, my lord, that should have been stated in the public interest litigation.
Lordship, I am representing the Pradhan, my lord. First issue, my lord. I don't know how it is public interest litigation. Purely private, more than private interest litigation, my lord. Firstly, he should state first if there is some sorts of conflict between Pradhan and Upapradhan, and if Upapradhan has lost certain complaint to BDO or anybody, how he got all these documents and made the annexures.
We were about to ask him.
This is in disguise, he representing the Upapradhan. If I am anyway kicked out from the Panchayat, by de facto he will become the Pradhan. That is the thing which is going on, my lord.
One thing we have pointed out to
my second
what we have at the very beginning pointed out that the allegations are absolutely vague, and the contractor has not been made a party. Now this is added to that. So you have been set up by the Upa Pradhan.
No, my lord.
My lord, one
This
point, my
somehow
lord.
I managed the
My lord,
documents
at least he should be honest that he has referred certain NIT copy. This is voluminous copy, 8-10 pages copy. He has given just the first page.
Actually, sir, these are all documents which are in the Gram Panchayat office. As a public interest litigant, you can obtain the documents if it is permissible under the RTI Act.
My lord.
Otherwise, source of the document is very important. So somebody else is firing off your shoulder. If they say it is the Upa Pradhan who's fighting with the Pradhan. How did you get page 37 document? You see the round seal of the Gram Panchayat is there. These documents you are not, this is an estimate which has been prepared, official document. Then page 38, signed by all the people, executive officer also. Then page 39 is approved action
My lord,
plan.
these documents has been obtained from the online, my lord. Rest of in the 2000, my lord, 23, after my lord making the complaint, my lord, no offline, my lord, online tender has not been done by the Panchayat. Every tender has been, my lord, flowed, my lord, offline.
My only submission, he should be at least honest to this point, my lord. The reference which he has made, not a single work order has been issued on this basis. My lord, if work order has not been issued, how corruption can be there? I have not execution in a single work.
My lord,
But he is raising.
Kindly, my lord,
This is
consider
very
the mass
serious issue,
petition, my lord.
Second
It
issue, my
says
lord.
32, my lord.
My lord, in their main petition, first 6 paras, 1 to 6, is concerned with him. 7 to end is totally concerned with the Upapradhan. Is he representing the Upapradhan? He has not been made party.
My lord,
Neither as a petitioner nor as a respondent.
my lord, after my lord beaten by the my lord
My
Pradhan,
lord, this is
some
not
of
his
the
case
members,
before
my
the
lord, to provide these documents, my lord, to
my lord, he has not made the
imaginary people,
things
lord.
open that he was beaten or I was beaten. This is not the fact in his writ petition. This is the subsequent issue about previous issue. I am not concerned. My concern is only to the point. His allegation is 1 to 6 and 7 onwards totally on Upapradhan's matter. So how Upapradhan's matter can be his grievance?
Some of the members, my lord,
in
support
this
me,
point,
my lord, to provide the documents.
my lord,
That's why, my lord,
You have stated that the Upa Pradhan wrote a letter complaint on 29/11/2024 to the Block Development Officer Malda. The subject matter of the complaint is NIT number so and so. How did you come to know of it?
My lord, the documents itself, my lord, some of the documents, my lord, the representation of the.
Please come. This writ petition has been filed as a public interest litigation, alleging that the Pradhan of the Panchayat has violated the norms while calling for tenders. We have gone through the affidavit file and have gone through the writ petition, and we find the allegations are absolutely vague. According to the petitioner, the credentials, according to the petitioner, the contractor who was awarded certain works did not possess the required credentials, and the certain forged documents were produced, based on which the Pradhan of the Panchayat had allotted the work. The contractor against whom allegations are being made has not been implemented as a respondent in the writ petition. Apart from that, the petitioner is not able to clearly explain as to the source of the document. It is stated that the documents were taken downloaded from the website. This appears to be a false statement because in page 31 of the writ petition, which is annexure P1, it has been meant the memo number 460/KGP/2023 dated 4/12/2023 contains the marking O/C, inverted comma, O/C, OC, which would indicate it is an office copy. Apart from that, there is a round seal of the Gram Panchayat. Therefore, there is some insider who has given the information to the petitioner, and on behalf of him, the writ petition has been filed. Furthermore, in the writ petition, the petitioner has stated about certain complaints given by the Upa Pradhan of the Panchayat to the block development officer. It is not clear as to how the petitioner came to know about such complaints. Thus, it can be prima facie seen that somebody else is behind this litigation. In any event, we are of the view that the allegations being vague, no direction can be issued in the writ petition as sought for by the petitioner. However, it is open to the petitioner to pursue his representation before the authorities. Next.
Serial number 14.
14.
Yeah, I appear for the petition. Well, in this public interest litigation, I've made an allegation that the Khash Mahal lands, which are the exclusively they're under this directly under the state control, they are being converted to Thika properties. Lordship, what are Khash Mahal lands, Lordship? These are properties which are directly under the state control. But Thika, Lordship, as Lordship would know, that there was a zamindar under whom the tenants were there. Subsequently, those by way of the Act of 1981 of the Thika Act, Lordship, those the lands had been vested. But my lord, the control, Lordship, is with the tenants. The tenants are there and tenants can apply before the relevant authority and can develop. But what has recently happened, my lord, in along the Canal East Ride Road, there are vast lands which are Khash Mahal lands. These Khash Mahal lands are being now converted to Thika properties. What the tenants, what they are doing, they are just applying before the Thika controller for declaration that these properties are Thika, and I do not know what the relevant parties, which is the Khash Mahal authorities.
No, Thika controller will have a list of properties.
Lordship.
Because in another matter,
Lordship, they are overlapping now. Lordship, a vested land cannot revest. That is the point. Lordship, these are Khash Mahal lands. But my lord, I must be candid that this cannot be disposed of without a report from the state. My lord, I have given example of one such property, which is 35 by 1B in my writ petition. I have given one such property, which is, Lordship, it is in the list of properties of Thika Khash Mahal. It is declared as Khash Mahal properties. But, my lord, I know of an order passed by the Thika controller by which this property has been declared as Thika. But, my lord, I do not have the copy of that order.
I have brought the order for my learned friend. If you can prefer an appeal, because statutory appeal is there.
But statutory appeal by the state, but I am not a party.
That is the
I am not a party
issue.
in that.
There are two ways of looking at it. One is the conversion is illegal.
Lordship.
On account of violation of procedure, etc., or on the ground there is an absolute ban on such conversion. Secondly is whether the government can take a decision. It is a land vested with the government.
Lordship.
With a particular classification.
Lordship.
So, if the government wants to change the classification after following the procedure, then if there is a defect in that procedure, whatever the enactment which governs that particular proceedings,
This Khash Mahal lands
has to be, that
adhered
remedy has to be
adhered to. I bow down, my lord. None of these had been followed. That is why, my lord, I'm asking that let the state file a report.
No, you said you have one document. Which
one document, Lordship will see page 36, which says, which is in reply to an RTI application that in the rent roll, may I please maintain in the office of holding number 228, this is the 35 by 1B, within division 3 as recorded is Ponchannogram estate in districts, and the total area of the holding as recorded is 3 bighas such and such. So, my lord, this is a purely Khash Mahal land. But now, my lord, I have alleged in my writ petition that there is an order passed by the Thika controller saying that this is a Thika property. Lordship, the Thika property, when it is declared, it is...
No, where is the ban for conversion?
Lordship, there cannot be a revesting of a vested property.
No, Thika property.
It is already vested. It is completely owned. The zamindar cannot be the state. The zamindar has to be the zamindar.
And where is that they converted into Thika property? Where
Lordship,
is
that I have alleged, my lord, which my learned friend very candidly said that he is in possession of that order. He has brought the order.
The West Bengal Thika Tenancy Act empowers the controller to take a decision whether a person is a Thika controller or not, Thika tenant or not.
and anyone who is enjoying the property thereunder is called a bharatiya under the Act. Now, my lord, this power vests under with the controller under Section 5. 5(3), this power vests with him. Now, my lord, returns, generally returns are filed. There are two ways this adjudication can be done, either on his own motion or through an information which is received. If someone may be an informant also. But in this case, returns were filed as a Thika tenant and an adjudication proceeding was started in 2006, which culminated into an order in 2019. Now, my lord, as once the order has been passed, that order has to be challenged apropos to the channel which is provided under the statute itself. This appeal to that extent will lie, my lord, before the West Bengal Land Reforms Tribunal, because it's one of the scheduled acts under the Land Reforms Tribunal. My learned friend is absolutely correct. He has availed of this avenue because he knows he cannot challenge that order.
I have no reason to challenge. Rashid, I am not a party to that proceeding.
Maybe, but then third party interest has accrued.
Lordship.
He is not here before us.
Lordship kindly sees, I'm inviting my learned friend to disclose who has been declared as a Thika tenant.
Yes.
Lordship, I know who has been declared as a Thika tenant.
No, you can't use us for that purpose.
No, my lord. Lordship kindly sees.
We are not here to procure information for you.
No, I'm giving the information. Lordship kindly sees page 37.
You have to. Your client has to do some more research.
Lordship,
he went straight to Supreme Court without any material. Supreme Court said nothing doing. Then he said, all right.
Like we will relegate it to High Court. Lordship, kindly takes page 37 for once, my lord.
Not relegated. Relegated means they will send. Liberty granted to approach for redressal of his grievance. Ask him to do some more homework. There are private interests accrued. See, if a person files an application, he says the proceeding started sometime in 2006, culminated in an order in 2019, recognizing X as a Thika tenant. That order cannot be upset in a public interest litigation. You are saying that the Thika controller could not have entertained that application. That's your
Lordship.
But
because if the Thika controller would have seen the documents, would have immediately come to the conclusion that there cannot be a zamindar. This is a state-owned property. Lordship, kindly see page 37.
He's passed an order. If it's a recent order, you have to we have to test the correctness of the order. That can't be done in a PA.
Lordship, for once, my lord, may I invite my lordship to page 37, my lord. For once, for my satisfaction.
Please.
Lordship, page 37, lordship will see the name of and address of managers, mortgages and tenants with character. Lordship, there is a column. Baldev Bagadia as chairman. That's the second paragraph, my lord. Baldev Bagadia as chairman and managing agent for Star Trading and Investment Company Limited. So this is the rent roll register of the Khash Mahal. This same Star Trading has been now declared as a Thika tenant. So he was a lessee under the state.
We'll consider. By this petition styled as a public interest litigation, the petitioners contends that the petitioner seek for a direction to the controller, Kolkata Thika tenancy, not to declare government Khash Mahal lands comprised in municipal premises number so and so. It's there in prayer ASR as Thika tenancy lands. The petitioner has not been able to mention as to who was the beneficiary of such an order passed by the controller or by the Thika controller. The petitioner would state that as per the rent roll register, which was annexed as annexure P2 to the petition, the property in question could not have been declared as a Thika property at all, as the state cannot become a zamindar. The learned senior standing counsel appearing for the state submitted that application was filed before the controller in the years 2006, and after due adjudication, an order has been passed in the year 2019 declaring certain properties as Thika property. If that is the factual position, unless and until that the said order is questioned in the manner known to law, the question of entertaining a public interest litigation to issue a sweeping direction to state that none of the Kash Mahal lands should be treated as Tika tenancy lands, is not feasible of consideration. Apart from that, if orders have been passed by the Tika controller, then it goes without saying that third party interest has accrued. And in the absence of the third party who enjoys an order passed by the Tika controller, the question of entertaining a writ petition as a public interest writ petition for such a larger relief would not arise. Therefore, we are not convinced to grant the relief sought for in the writ petition. The same is dismissed. However, the dismissal of the writ petition will not prevent the petitioner from working out his remedies in accordance with the law before the appropriate court.
There is another thing, my lord. Section 15 of the Tika Act, my lord, that is the bar. From state, yes, my lord, the state government, the lands by the state government, they cannot be declared as take.
My lord, before considering all that, appeal provision starts with the words any person aggrieved. If he is any person, he may prefer an appeal. But whether he will fall under the period of limitation or not, I'm not sure.
Appealing for the petitioner referred to the West Bengal Tika tenancy within bracket acquisition and regulation bracket close Act 2001 and referred to section 15 and submitted that in terms of clause A of section 15 nothing in the act shall apply to lands belonging to central and the state government. The issue which has to be considered is whether the land is a Tika property or a government property. After due adjudication, the Tika controller has declared it to be a Tika property. Therefore, if at all a person is stated to be aggrieved by such an order, then the such person is not without a remedy, as appeal provision has been provided under section 12 of the Act. It is pointed out by the learned senior standing counsel for the estate that in terms of subsection 1 of section 12, any person aggrieved by an order of a controller may prefer an appeal before the West Bengal Land Reforms and Tenancy Tribunal. West Bengal Land Reforms and Tenancy Tribunal. That paragraph. Therefore, unless and until the orders passed by the Tika controller are challenged in the manner known to law, the question of issuing a sweeping direction in a public interest litigation would not arise.
I'm grateful.
Yes, sir. Thank you. Next.
Serial number 15.
15, appealing for the statement. The other.
Well, I am for the this is with regard to safety and securities of the women who are working at night shift in the IT sector. I have given the instances of the state of Telangana. Kindly see what steps they have taken. In the state of West Bengal, this notification has to be issued as regards the safety and security who are working in the night shift in these IT sectors, especially in the sector 5 of the Newton area. Page 39, I have given the abstract of the Telangana government's notification. This is the complete guidelines. So far I understand. These may be introduced by the state of West Bengal. This is my prayer. And the government of West Bengal only introduced one order which is appearing at page 25 Jatri Sathi. Ratre Sathi Ratre Sathi.
Well, there's another one also.
This is my
there is also a mobile police patrol.
Yes.
I've seen
And
Shakti.
And another one is called winners, my lord. That is for the IT sector, that area around IT sector, which has been done separately, my lord. Other than improving of the lighting in that Navadiganto industrial township area, my lord, to my lord, reduce the dark spots in the road, which are there, my lord. And my lord, a specific force of lady police force, my lord, under the name of winners, have been constituted to take the rounds of that area, my lord, at night, my lord. And my lord, also separately measures have been taken, my lord. My lord, if I may hand over this, my lord, it will be, my lord, convenient, my lord.
They want some comprehensive guidelines or
Guidelines, my lord, for the
notification.
yes, my lord, for the guideline, my lord, I have already, my lord, tried to sensitize all the concerned departments to sit together. That might require some time, but I am trying to apprise what steps we have already taken, my lord. My lord, 1 and 2 I have already spelled out. 3 is the CCTV, my lord, which the maximum possible, my lord, coverage so that we have, my lord. The CCTV we have installed, my lord, to monitor and deter the potential threats. Number 4 is the self-defense training, that we have organized regular self-defense training session for women employees, which the project name is Bagini. Our women winners team, lady police, patrolling surrounding a PS area regular basis on their bicycle. Our RT mobile van, well, this is anyway there. Number 6 is always there. RT mobile van performing patrolling duty surrounding the PS area day and night to prevent any untoward incidents. And we have also deployed police personnel in plain clothing, including lady police in different places in the PS, like so and so, so and so, so and so bus stand during office time, so and so. The petitioner, Malad, is also, Malad, he can, if apart from these areas, he wants some other places to be looked into, he can, in the meantime, Malad, give it to us. Malad, we will take care of those areas as well.
Petitioner who claims to be a public spirited person filed this writ petition praying for a direction upon the respondent state to issue appropriate notification so as to protect the women who are employed during night shifts, more particularly in the IT sector. In this regard, the petitioner has referred to the notification issued by the government of Karnataka, notification issued by the Haryana government, and the notification issued by notification issued by the government of Himachal Pradesh and the notification issued by the government of Telangana. Thus, the endeavor of the petitioner in this writ petition is to request the state of West Bengal to formulate a comprehensive guidelines and issue the same in the form of a notification so that all commercial establishments and the IT sector companies comply and the safety and security of the women employees are protected. The petitioner accepts the fact that the government of West Bengal has introduced a flagship program called Ratiri Sati, RATTIERER SAATHI hyphen helpers of the night for the safety for women, especially for those working during night, and which was launched following the guidelines which were implemented in medical colleges, hospitals, hostels, etc. We find that in the said guidelines, there is also a guideline. There are various directions issued. No, sorry, sir. For helpers of the night, for safety for women, especially for those working during night shift, has been launched and to be implemented in medical colleges / hospitals / hostels, etc., wherever provisions are not already available. The learned government advocate, learned as senior standing counsel for the state, has produced the written instruction given by the inspector in charge, Electronics Complex Police Station, Bidhannagar PC, dated 16/1/2025, wherein the safety measures which were implemented by the police authorities in the said area, falling within the jurisdiction of the concerned police station, has been set out. The endeavor of the petitioner appears to be to introduce a comprehensive guideline so that, and if it is issued in the form of a notification, the private establishments and other institutions which are carrying on business in various parts of the state can be called upon to implement the same. And if the notification has the statutory flavor, then enforcement of the terms of the notification can also be done, which will effectively address the concerns expressed by the petitioner. The learned advocate, as a senior standing counsel for the state, on instruction submitted that all the departments are being sensitized, and very soon something positive will turn up. Thus, considering all these facts, we direct the Principal Secretary, Department of Home and Hill Affairs, to form a team of officers to examine as to how a notification, preferably a statutory notification, can be issued for the purpose of ensuring safety of the women, especially those who are working in night shifts. Which notification to be made applicable to not only the government sector but also to the private sector. The said team of officers shall examine the issue and submit a draft and submit their draft recommendation to the Principal Secretary, namely Hill and Home Affairs, Home and Hill Affairs, who after thereafter take the matter to its logical conclusion. With the above observation, the petition is dismissed.
I'm extremely grateful. One.
Yes.
The affidavit of service may be taken under.
Yes. Next.
Serial number 16.
My lord, item number 16, I behalf of the petitioner, but led by Shankar Prasad Dalapati. And led by Shankar Prasad Dalapati and praying not today, my lord.
Why?
My lord,
You
He's
argue
not feeling well.
Simple point. What is
this issue is very short, my lord. This private respondent, the allegation is prayer that he, by blocking the canal, carrying on PC culture. Now, this gentleman, private respondent, there is a series of adversarial litigation between this private gentleman and the state also. We are on the point that your lease has expired, you quit. So on this issue, my lord, there are, my lord, a series of adversarial litigations. Now, one such order my learned friend has annexed at page 1313. I find that this private respondent is the appellant. Kindly sees, my lord. He comes with a particular order. Kindly sees page 14. No, page 15, lordship, page 15. The petitioner has challenged one of such orders before this court, whereby the learned single judge passed no protective order in his favor. So he wanted to continue. Our contention, kindly see next paragraph. It is the case of the state respondent before us that though the lease period commenced from so and so, in effect in possession from so and so, therefore the deposit of lease rentals made by the petitioner in the region of so and so, the lease rentals for the period so and so, the lease granted in favor of the petitioner has expired on 14th April 2022. This was a stand before the intra-court appeal. Now, finally, what the intra-court appeal, the Honorable Division Bench says, kindly sees at page 16, last paragraph. In that view of the matter, we direct the OC of the local police station and the state respondents to ensure that no obstruction is created by anyone in carrying out the pisciculture business by the writ petitioner. Appellant in the fishery allotted to him for a period of 2 months from date. The respondent shall be at liberty to file affidavit in opposition to the writ petition before the learned single judge within 2 weeks from date. Reply thereto if any be filed within 1 week thereafter. The parties will be at liberty to mention the matter before the learned single bench seeking any further order, including interim protective order, as we have passed today, so and so. So, my lord, so now this single, this WPA number is not mentioned in the throughout this intra-court appeal order, my lord, but whether it is pending or not, my learned friend is appearing for the private respondent, he is in a position. Now, I received one order, I received one instruction from the OC of the local jurisdictional, my lord, the police station. He says in, kindly lordship, may I respectfully invite your lordship to page 2, my lord, of the report. 6th paragraph from the top. Kindly sees thereafter on 17 December 2024, a judgment has been passed by the Honorable High Court, Calcutta, vide WPA number so and so of 2020, that the interim order last extended on September 30, 2024, which is still in existence, stands further extended till March 15, 2025. So this is what, my lord. So now if the prayer is that he should be removed, he should be, so lordship, in this, since the adversarial litigations are already pending.
But you please see the last paragraph. Pertinent to mention, Honorable disposed of the case and so on. So
Series of other petitions are there.
Your lordship,
Series of petitions.
petition bench order is being shown, your lordship, that litigation is pending. The state till date has not filed their affidavit. The direction was to state.
It was remanded back to the single bench. So that means that is still pending.
Still pending.
I wanted to know that.
It's still pending. Is WP number 1101.
Who's this man who has filed this PIL?
Your lordship, basically there are 2 points of this litigation. One is we are paying the revenue to the government and we are enjoying the fishing culture. They are saying that they are the original owners of that. They don't want to pay the rent and they want to enjoy the fishing culture. That's the difference, your lordship.
Oh, not
we are an organized fishing body, your lordship. We are an organization registered under the government of West Bengal. We are conducting it by taking lease from the government of West Bengal. We are paying the lease. Now the dispute is that period for which we have been allotted the lease, where we will be able to enjoy it or not. That was the question with the division bench as well. Division bench said the remanded matter.
They are the owners of the land.
They are saying under Rule 273, if they are actual owners of the land, they can get a privilege over there. So that is their question before the court, that we are the actual owners of the land. So we should be given it for free of cost. Now we are paying the rent and enjoying the fishing culture. But the dispute is still continuing. There's a direction of
right. You implicate yourself in that writ petition.
Lordship, pending a writ petition.
He can intervene. If the intervention is allowed, you
Lordship.
By this public interest litigation, the petitioner seeks for a direction upon the authorities to remove the article barrier created by the private respondent, which is disallowing the water of No.1 from flowing into Bhagirathi River. Though the petitioner has been styled as a public interest litigation, there appears to be certain other issues which dissuades us from entertaining this writ petition. One such issue is that the private respondent has filed a writ petition before this court, which is still pending, and as against the refusal to grant any interim order, the private respondent filed an intra-court appeal in MAT 625 of 2022, in which there is an interim order granted, and it is stated by the authorities that the interim order has been extended till 15th March 2025. Thus, there is inter-se dispute between the state and the private respondent. And in the interim, direction cannot be granted in a public interest writ petition. If at all the petitioners want to put forth their case, the only remedy available to them is to intervene in the pending writ petition if they are so advised. With the above observation, writ petition disposed.
Grateful.
Next.
Serial number 17.
But this relates to
yes, sir.
This relates to my lord filling up of water body, the non-usually. From paragraph 4 onwards, I have stated, my lord.
For the respondent number 7, against whom we have certain evidence.
Well, I'm taking for the state.
The national highway number 60 is there, and in by the side of that national highway, my lord, the non-unis are there. The surrounding areas, people have, my lord, before your lordships.
But there is some direction issued by the executive magistrate Kharagpur
That is, my lord, since
to BLLRO Kharagpur to
My
conduct
lord.
an inquiry.
to
My
submit a
lord.
report.
4C application filed by the private respondent, my lord, that has been allowed, my lord. And my lord, land converted from Noyanjali to Bastu, my lord. Then, my lord, they got a sanction plan, and my lord, they started construction over there. So, my lord, if any remedy, my lord, they think.
We have to file
My
an
lord,
application.
Noyanjali
Section
is the
54
government, it cannot
application
be
with-
private property. That is my specific
But we
pleading.
can't issue a writ when there is an order after adjudication. Some forum has to hold that that order is an illegal order. We can't issue a mandamus and say you cancel that order.
No, my lord, kindly consider the Noyanjali is cannot be the private property.
It cannot be, but on what basis that 4C order was passed, we don't know. You go before
Well,
the
on the
appellate-
basis of the prayer of the private respondent, the block land as per my learned friend's submission, as per the prayer of the private respondent, the block land.
So the private respondents made a prayer. All prayers are not granted. There should be an adjudication.
But my
There
question
should
is,
be a recent order which is passed by the BLLRO.
but my question is how a Noyanjali can be private property?
You have to ask it before the
Well,
appropriate.
it is the state has to reply that the Noyanjali,
My lord,
well, Noyanjali cannot be the private property.
No.
Purchased the property in the year 2004. Thereafter, I made that conversion application in.
No, their contention is you could not have purchased the property. Nobody is the owner of the property except the state.
They have annexed my deed of.
Yes, I have annexed that. I have annexed after getting the information from the private respondent that they have purchased. I have obtained the certified copy of the deed.
That senior allows me, then I can say few lines. At 2004, I purchased the land. Whatever averment they are making that I purchased entire plot of land, that is not true. My deed specifically talks about the fact that I purchased 11 decimal plot of land out of 39. So remaining knowingly is there, whatever they are saying. And so far as my plot of land is concerned, I applied for the conversion, granted for a limited portion, upon which, upon getting permission from the concerned authority, I am erecting my concern. Similar, how I am blocking that canal? Because 39 entire plot, out of which 11 I have purchased. 39 is not a canal, my lord. Whatever my learned senior allied, the canal is remain as it is. I am not even touching over there.
But how you could have purchased a canal?
The Rayati land was there, my lord. Kindly take my.
But it is in Bengali. I don't.
Lord, I have also the Bengali copy.
No. How does your vendor acquire title to that property?
My lord, vendor has a Rayati property over there.
Rayati property.
Right. But right, yes. Because record shows that.
In the schedule, what is the description?
In the schedule, my lord.
Where is the schedule?
Page 13.
It is still nature of the land, still Noyanjali. The record of rights, it is page 24. It is Bengali document. It is.
What he says is only 11 decimals he has purchased.
My lord, it is a canal. If he block it, my lord, how that the flow will be stopped?
Let kindly take page 46 from my learned senior's petition. It would be evident. My lord, there is two plot. One is 1329 and another is 1328. 1329 is a canal.
48 is it?
46. The application which was made before the learned executive magistrate by my learned senior. But their schedule has been mentioned. Suit land. Kindly see the first schedule, my lord. Khotiyan number 822 and plot number 1329. And then they said non-suit plot, then Noyanjali, plot number 1328, area 39 decimal. Now, my lord, this is their averment. But so far as deed is concerned, which I have purchased, my lord, over there, the vendor has categorically stated it is his right land. Then I have purchased. Why should I, my lord? Unnecessarily, I will go and purchase the, my lord, Noyanjali after paying the sale consideration.
46.
Page 46, my lord.
But in the schedule, it is Rayati land.
No, my lord, kindly come to page 44, 24. It is although it is Bengali document, but my lord, his name is there, Pradeep Kumar Samanto. And my lord, Sreni, that is nature of the land, it is Noyanjali. Plot number is 1328. Page 24, Mr. Justice Patnaik will see that. My lord, page 24, it is Bengali document. My lord, the plot number is 1329. My lord, the Sreni is Noyanjali. And my name of the Rayat is Pradeep Kumar Samanto. How that can be?
In the petition given in page 44 to the executive magistrate,
My lord.
46 is the schedule. You have given two plot numbers.
Yes.
And one you say non-suit plot 1328. That is what he has purchased 11 decimals
Out
in
of
1328, which according to you is a non-suit plot.
In the writ petition, my specific case is, my lord, 1328. 1328 is non-Julie. In this writ petition, that is, my lord,
This writ petition styled as a public interest litigation alleges
Well,
that the
the-
private
the-
respondent has illegally put up construction in a water body / Nayanjali in plot number 1328. The learned government council on instruction submitted that the private respondent has purchased an extent of 11 decimals out of total 39 decimals in plot number 1328, applied for conversion, and proceedings were initiated under section 4 capital C of the Act, which has culminated in an order allowing conversion. Thereafter, the private respondent has applied to the authorities for obtaining building plan permission, and thereafter construction has been put up. The learned advocate appearing for the private respondent refers to the sale deed executed in favor of the private respondent by the vendor, wherein the property has been described as royalty. Furthermore, in the petition given before the executive magistrate Kharagpur, in reference P case number 533 of 2024, for a prayer under section 163 within bracket 2 of PNSS filed by the petitioner, in the schedule, the suit land has been shown as plot number 1329, data number 822, measuring an extent of 9 decimal. The non-suit plot, according to the writ petitioner themselves, is plot number 1328 of area 39 decimal, which is a Nayanjali. As long as the order of conversion has not been put to challenge in the manner known to law, the question of issuing a direction in a public interest writ petition to set at naught the order passed by the authority after adjudication is a relief which is impossible of being granted. Therefore, while disposing of the writ petition, we leave it open to the petitioner to question the conversion or order of conversion, if so advised, in accordance with it. Next.
Serial number 18.
As the affidavit has not been exchanged, all the allegations are grateful.
I beg to appear for the petitioners. Well, my allegation is, Millard, I am a public spirited person of the locality, Millard. The private respondents are having small plots of land, but they are encroaching upon public road 1. They are also encroaching upon by way of construction on the canals, which are being basically used as a sewage. And Millard, they are having constructions where overhead wires or electric line of around 11,000 kilowatt is passing, which is not permissible, Millard. And in spite of representations, and Millard, they have not also converted the land. If my lord, may I be allowed to take my lords through the photographs? If my lord kindly comes, it's though in Bengali in page 22, lordships. Lordships will kindly see. It's Shreni Danga. My lord, just Patanayak will kindly Shreni Danga, lordship. I am also not. Danga means, my lord.
Danga means Bastu land.
No, yes. Danga means, my lord, where agriculture is not possible.
No, it's not possible. But then for making it into Bastu, my lord, what we could gather, my lord, it has not been converted into Bastu. Be that as it may, my lord, that is not the only point which I am trying to make before your lordships. Now, lordships will kindly come and see the construction at page 23, my lord. The private road or the public road is being encroached upon, and my lords will kindly see the overhead wire, electricity wires, my lord. Well, this is lead to catastrophe at any point of time, and under the Electricity Act and the rules framed there under 63, 64 and 65, my lord, they cannot have any construction.
What is the nature of factory?
My lord, rubber factory.
No.
They are storing rubber, whatever it is, my lord, let a report be called for. I may be wrong. I may be right. Let the state come up, because I have made representation, my lord.
Have come up. There are 2 plots. One here shown at page 22. It's a Danga land. It's a royalty land. Another plot is, my lord,
913 at page 26.
26, Lordship.
This is recorded as Rasta.
That is road.
That I'm saying.
I apologize, sir. I apologize.
Bottom of it is Rayat's name is district board. That is municipality. His allegation at paragraph 3 of page 8 is that 4 feet has been encroached of the district board's land, that is municipal land. This is the allegation, and with regard to canal and water body, he has not given any particulars. Kindly see page 8, paragraph 3.
But is the area residential area or industrial?
Residential area, my lord, I beg to appear for the private respondents, my lord. What happens? One, my lord, Abdul Latif, my lord, he was, my lord, making illegal constructions. The private respondent, my lord, lodged complaint before the concerned police stations and the municipality. Municipality issued notice on 19/10/2024, my lord. Then, my lord, the petitioner also moved an application, my lord, under section 144, my lord, 163, my lord, act, my lord. And the order was passed to stop the construction. This is the, my lord, the wall they are making. This petitioner, my lord, she is from Bardhaman district, and this area is, my lord, South 24 organized district, Bajwaj area, my lord. My lord, she is the friend of Abdul Latif's wife, my lord. He got this case filed, my lord. This is the, my lord, and the municipality authority, my lord, issued notice issued upon the Abdul Latif to stop the construction. And then, my lord, 4th December, my lord, this demand of justice or representation was made before the concerned authority, and they have come before your lordship, my lord. This is, my lord, the counter blast, my lord. And, my lord, I have never encroached, my lord. And, my lord, I have got the, my lord, the exact picture, my lord. My lord. Road sides, canal is another side. This is the boundary wall, my lord. That wall is.
The address given is
it is into, my lord,
residing at so and so Bardhaman and
No, my lord,
presently residing at Eden City.
My lord, that has been given, my lord. Only to, my lord. And she is from Bardhaman district, my lord. And, my lord, in the
and the property with this.
My lord,
it is an Eden. What I have been told, my lord.
South 24 my lord, Pojali police station.
Part of particulars as to what is the waterland. What is
My lord,
the
what I am humbly submitting is, my lord, if, my lord, first of all, the state, being a welfare state, my lord, they should, if there is any wrong.
No.
My lord,
my lord, my lord, it is 10 kilometers away.
Municipality, my lord.
It is 10 kilometers away from my residence at Eden City. That is what I have stated, my lord, and that is there
that has
in the
been,
first
my lord,
paragraph.
That has said, yes.
My lord,
But now the private respondent has made some complaint against somebody. There is an order of stop construction.
We don't have any relationship with them. First of all, my lord, and my lord, let the state come. If the state, we have made a representative. Now, if there is something wrong, 2 wrongs will not make 1 right. This is what I'm humbly submitting before your lordships. If a person has encroached upon
what happened to his
public
representation? What happened to his representation?
representation to whom kindly see, my lord? Page 31, possibly.
Yes, lordship. Page 30, my lord, it starts at.
I may be wrong.
Which authority to take action, sir? Except
Municipal authority.
I think 3 people you have missed out. Your client has missed out. One is the Excellency, the Governor. One is the Honorable Chief Minister, and one is the Chief Justice.
My lord, and my lord, trained one.
That entire state of West Bengal you have given.
My lord, it is the municipal land.
And this man will say, no, this is not my problem. This is somewhere there.
Municipality
He'll put the
action, will let the municipal.
My lord,
Give us specific. If suppose
My lord,
PLLRO has to take action, municipality has to take action, or the SDO has to take action.
My lord, in number of
District-
cases I have produced before your lordship, 17 capital A, notification of 2017. Municipality is the authority in this matter.
He is given it, Pujali municipality.
But if we have given it,
He is the 12th notice. So he will not look into that itself.
my lord, we have also given it to the district
Did,
magistrate, my lord. As well
by
as-
way of this public interest litigation alleges that the private respondent has put up illegal construction, encroached into a road, encroached into a water body, etc. However, from the averments made in the writ petition, we find the averments to be very vague. The learned advocate for the private respondent submitted that the writ petition is not a bona fide public interest litigation, but there is a vested interest since the petitioner is canvassing the case of another person against whom the private respondent had lodged a complaint to the municipality and the municipality has issued stop work notice to the said person. Be that as it may, we find that a representation has been made to the authorities by the writ petitioner, making certain allegations. However, which are said to be sent to by, which is said to be sent by speed post. On going through the representation, we find there are the petitioner has addressed 16 authorities and is not clear as to which authority has to take appropriate action. Therefore, based on such representation, we cannot issue any direction for even for consideration of the representation. Therefore, we dispose of the writ petition by giving liberty to the petitioner to give a comprehensive representation containing full details duly supported with documents to the appropriate authority who is required to take action. And the petitioner should appear in person before the said authority and place the representation. On receiving the representation, the authority shall examine the same, and if a case is made out for conducting inspection, he may do so after notice to the private respondent and proceed to take action in accordance.
I'm grateful, Lordship.
My lord, I'm grateful.
Serial number 19.
19.
Lord, I beg to appear on behalf of the petitioner. This matter pertains to a huge financial
Led by
scam.
Mr. Kishore Dotto, Advocate General, my lord, I was praying for not today, your lordship. My lord, he's on his
Matter,
leg.
my lord, pertains to a very huge financial scam, my lord.
Exactly, your lordship.
My lord, government of West Bengal had introduced a scheme for the, my lord, economic empowerment of the Lepcha community. They are the backward class and my lord, downtrodden in the area, my hill areas, my lord. But two schemes. One is for my lord that is called wrongly housing scheme. That is for initially 2,000 families were my lord, identified as my lord, beneficiaries of these schemes. And the second schemes is that housing schemes. That is my lord, also 2,000.
We dealt with a similar matter earlier.
Hill areas.
No, same Lepcha development scheme.
Nobody has got any benefit, my lord.
No.
Amount disbursed.
Actually, that learned advocate, he came from Jalpaiguri.
Any order passed, my lord?
Yes. In fact, we issued notice. I think Additional Advocate General, somebody appeared, and ultimately we dismissed the writ petition. And he said that he has first-hand information because he also comes from the hills.
But my lord, kindly says my prayer, my lord, for the
No. We want to see that order.
order. No.
Where is that order?
My lord,
you don't know. Then who? Same thing he said. It was not disbursed to them. The beneficiaries' names were considered.
Do you have any complicated?
But who appeared for the state in that matter? Long before.
And that was there also.
Yes. The account number is not there. That is not tallying. Same thing. Yes, sir. I think so. Same matter.
And let me, my lord.
Could be the same annexures also.
And let me, my lord, do some, my lord, research work to find out that order. If it is so, my lord, then.
Then if it is so, you withdraw better.
Yes, yes.
Pardon, sir? Donal Lepcha.
No, this is a separate one, my lord. It's wrongly left, my lord. That is.
Wrongly Lepcha.
Yes.
Nimsha Lepcha.
I have to see whether the parties are the same or not, my lord. That is also, my lord, because there's a different vote. It may be, my lord. This Indigenous Lecture Tribal Association, ILTA.
After hearing the learned advocates for the parties, one of us within bracket recollects that an identical matter was moved before this court as a public interest litigation, and certain orders were passed. The learned advocate for the appearing for the petitioner does not have any information about the same, nor the advocate appearing for the state. So the matter is adjourned by 3 weeks. In the meantime, the learned advocate for the party shall verify as to whether any other petition was filed earlier.
Pending. Kindly then,
you are appearing for the bank.
My lord, kindly tag with this matter then, my lord. If it is pending.
First, you do the homework and next.
Serial number 20.
May I file the affidavit service? Affidavit service.
My application. So the central government.
Once we are.
Kindly see page number 31 once. The government of India accorded approval for diversion of forest land for mining purpose on the permission by the state government on behalf of the allotee. Upon the proposal of the state government. Now there are certain conditions, 10 conditions has been laid down. Now page number 31 says the first two regulations, page number 31. Point number two. Legal status of the forest land shall remain unchanged. Compensatory afforestation shall be raised over 1.155 hectare of non-forest land at the project cost, and the plantation should be subsequently notified and such and such. Thereafter, we made an RTI. The father of the petitioner made an RTI asking.
No RTI, complaint.
Complaint.
My father filed a complaint 10 years ago.
He makes a complaint seeking that what are the things has been done for the update. Can you see the page number 2, page number 33? There's a P2. It indicates the government has acquired this land for afforestation purpose.
I can't understand this document.
Yes,
33 to 34.
In the Bengali vernacular.
All right. Come to page 40.
40. Yes, this is the father's letter. Thereafter, when nothing happened, in the next page 41, it gives a reply. For taking necessary steps to the state government. Now, what happens? Now the petitioner herein, he files an RTI before the forest respond number 4. Now they reply that page number 44, with reference to the above, this is to inform you that the matter is near about 15 to 20 years earlier, and to answer your queries, the old office records had to be searched for. Now, the only question we have raised, whether the afforestation, the clause has been fulfilled or not. And on the different pretexts, they give different replies. I'll show the next page number 50 also. They give a different reply. Well, these conditions has not been complied with. We have several times seeking the information, but not given to us. And sometimes they say that the matter is pending before the CBI. We have inquired through RTI also. So this is on different context.
The files are with the police.
Yes, my lord. But we made an RTI to that also, my lord. We found that is with a different aspect, not in this regard. My lord, they have started illegal dumping of the ashes on that plots. Now we want to file a.
Now the Ministry of Forest has forwarded your representation.
Yes.
To the Principal Secretary, Government of West Bengal.
Yes, and they give a reply stating that this is without.
Page 64.
Yes, my lord.
What is the reply for that?
No, like, we have.
No, there's no, this is, they forwarded your legal notice to the state to take action.
Thereafter I wrote a legal notice, but they did not reply. But I am inhabitant of that area. I am well-known person that there is no afforestation over entire vast entire portion, accurate portion. Those were identified. Those were identified for the afforestation, but no afforestation was carried on. No afforestation was met. Thereafter, I have my father submitted complaint, but no action has been taken by the respondent authorities. No afforestation till now has been raised.
What is your instructions of state?
All steps has been taken, including my lord. Complaint has been raised. Chief Judicial Magistrate posting Bardhavan, and next states for hearing, my lord, with 8 February this month. And regarding illegal dumping of. Regarding, my lord, afforestation is under 1 decimal, only 1 decimal, surrounded by other land. How can it possible? Is it? Other lands of the private respondent. How can it be possible, my lord? Because original forest is so long after. Only 1 decimal land. That is why at dump we have already taken steps regarding.
No, my lord.
Illegal dumping.
The one
lodge complaint before the CGM, Chief Judicial Magistrate, posting Bardhavan.
1 decimal belonging to the accurate land, which was identified for afforestation. They have already made diversion.
Say there are lands which are private lands surrounded the property.
No. That is belonging to the identified land. Those are identified for the afforestation.
So far as the allegations of violation of section 63 of the Forest Act and section 3 of the Prevention of Damage to Public Property, criminal case has been lodged. CJM Asansol has taken cognizance of that, and the matter is to be heard on 28th February 2025. That is on the criminal side. Now, what is the relief you want? They have dumped ash, is it?
This is a prayer.
My lord, 1.54 155 acre was acquired for the compensatory afforestation in Rosunpur Moja. But no afforestation till now has been raised. And
That is, if that project has to be implemented, who has to implement the project? The private
respondent.
No, is it the state or the private respondent?
Both are liable. Both are liable. Page number.
Done, my lord, regarding 144, the afforestation, compensatory afforestation, we have already done.
My lord, page number 31.
Put only 1 decibel drop.
Page number 31, compensatory afforestation shall be raised over 155.01 hectare on non-forest land at the project cost. Project cost mean cost provided by the private respondent. And the plantation should be subsequently notified.
As a reserve forest. As a reserve forest.
Yes.
Or a private forest.
Under the provision of Indian Forest Act.
Now, in your representation, what is the allegation against the private respondent?
My allegation is no afforestation has been done by both the private respondent and
the state
or the state. Any single example, they cannot provide that afforestation has been done.
Well, state has already been taken steps.
Where is your report?
This is
You file a report. Private respondent to service appeal.
Paid the money.
Money would have gone somewhere.
Well, I'm told it's done.
But he is from that area.
I am inhabitant of that village, Rosunpur village. I am inhabitant of that village.
And his father is the RTA applicant. Earlier also he has appeared.
My lord, there is another thing.
We know that. We know that. We don't want to open. We don't want to open up that issue now. But when time comes, we will.
My lord, second page of the report, let's see, second page of the report. A monitoring, what bottom portion, second page, this is the first page. We are not page later, I'm sorry, extremely sorry, my lord. This is the first page, and second page, bottom portion. A monitoring team of MOE, that is in the year 2015, visited the plantation sites related to the ICMN project. What is my look? Technical officer forestry submitted a detailed report to the director, Ministry of Environment, Forest and Climate Change, Indira Portavoran Bhavan, Aliganj, New Delhi, where they stated the plantation are successful, except Rasulpur, as there is severe hostility of villagers, although it is mentioned in the report that compensatory plantation was done over 62.89 hectare area in the Rasulpur Muza in the year 2004 and over 153.91 hectare land overall. In response to the paragraph 5 of my report, Lordship, kindly see. In the meantime, Sorisati told me that the private respondent CSC Limited applied for diversion of plot number so by proposal number
So, according to this report, they have filed a report now, along with some annexures.
My lord,
initially the plantation has come up well, but subsequently it was damaged primarily because of grazing and waterlogging. So somebody has S. Mukherjee, CF Central Circle, he has drawn a report. Have you given copy to this?
my lord, there is a startling fact which I got from the central government. I am filing that.
Central government also satisfied. They have plantation.
No, my lord, please peruse this.
Please. আমি একটু কপি দিয়ে দেবো আপনাদেরকে কপি দেবো
Okay, I will serve. My lord,
You do one thing. We will adjourn the matter next week.
my lord.
Meantime, you go through this bunch of papers given by them. Study this
My
paper.
lord, but this supplementary relating to supplementary affidavit, I need to say something. My lord.
Okay.
My lord, during pendency of the PIL, I have filed a further application before the central government relating to with a view to know the proposal in generally when as per rule 4 subsection sub rule 1 of the forest conservation rules 1981, a proposal is filed before the central government by state government or any other authority, then the central government considering the proposal grant approval to the central government to in favor of the LOT, and at that time prescribed form is filed before the central government. I asked for the said proposal, asked for the said proposal prescribed form, wherein totally matter is elaborately mentioned within which period the afforestation should have been completed, how species of the plants to be planted, everything. But my lord, peruse the
He submitted RTI application before the.
no. Entire form. I got entire form proposal from the central government, wherein period for afforestation has been clearly mentioned as 3 years. But 23 years has
But
elapsed.
what they say in this, that is why we are advising you to go through this bunch of documents.
My lord.
They say attempt was made, but that was not there. The soil has to be, the land has to be filled up. Thereafter, sowing has to be done. Then only we can do. Apart from that, there is local resistance that they are saying in this.
No, my lord.
You read the paper and come. No, you can't do magic. What we could not do, according to you, for 20 years, we can't do it in 2 hours.
One thing.
Trees don't grow in a day.
No, my lord. One thing. Chichurbil Moja has been identified in the said proposal, but Chichurbil Moja has been.
The best thing is either you stand for election, become MLA, MP. That's the only best option.
Sorry.
So if you are a local person, you are a popular person, you want to do something for the community, become a legislator. That's all. In this public interest litigation, the petitioner has made several allegations, primarily on the ground that compensatory afforestation has not been done. The Chief Conservator of Forests, West Bengal, has given parawise instructions to the Learned Common Council, copy of which, along with annexures, copy of which has been handed over to the learned advocate for the petitioner. The learned advocate for the petitioner has filed a supplementary affidavit, which is taken on record. Let copies be served on the learned advocates for the respondent. Time is granted to the petitioner to respond to the documents which have been furnished by the Forest Department. Give a date after 2 weeks. Next.
Serial number 21.
Supplementary affidavit, you please give.
My lord, I am giving.
Item 21.
21, I'm bringing for the state.
21, I appear for the petitioner. This is a matter. I have come before your lordship, challenging the inaction on the part of the subdivisional officer who has issued the OBC certificates to the respondent number 8 and 9 in such a fashion that, according to me, that the respondent number 8 and 9 are not entitled to get that OBC certificate. This is number 1. But I have raised a question, if your lordship kindly turns to my representation once and the hearing of the SDO page 57. I'll cut short the issue, kindly straight away comes to page 57. This is the hearing on 1st of April. Kindly do not consider the date. 1st of April.
I was sworn in as a judge on 31st of March 2009. That was a Saturday, because 14 of us. No, it was not a working day. Okay. 14 of us were sworn in.
Yes.
Our first sitting was on 1st of April. Not clear. Caste certificates found are genuine. That's all.
Yes.
After considering the report of BDO, After first hearing the respondent 8 and 9, called, hearing linkage certificate holder parental side, petitioner, so and so reports. Subdivision officer received a report regarding issuance linkage trait. Another inquiry report of subcast, block development, so and so. Then what is wrong with this report?
But I tell you, Lordship, no copy of the report based on which this order was passed was ever served on us. This is number one. Number two, if your Lordship kindly turns to the list, kindly sees page 19, list of OBC recognized by the government of West Bengal. Number page 19, my grievance is in page 20, starting from 65.
Sir, even when we disposed of the earlier writ petition, we had made it clear that the issue being a disputed question of fact cannot be adjudicated in the writ petition. If an individual comes that he has not been given a OBC certificate or a scheduled tribe certificate, then the single bench will consider whether proper inquiry was conducted, field inquiry is conducted, family customs, etc., other habits and followed, then they will direct. But here at the first instance, we said the issue being a disputed question of fact cannot be adjudicated in petition. Nevertheless, a representation was given. The sixth respondent may inquire into the matter. He has inquired into past. You challenge that order before the
Appeal is there.
court.
Appeal is,
Appeal is there. That is already provided by Supreme Court in that, what is that case, sir? Padri Patel. Initially itself, there should be a state vigilance committee. Everything is there. That all hierarchy.
I have annexed the memorandum. Kindly turns to page 58 once. For my satisfaction.
Appeal provision page 63.
But you and a PIL, what to do, sir? We can't do.
But for all times to come, his remedy cannot be in a PIL. Today he's assuming he doesn't go up in appeal under this, but he is challenging the order of the SDO. That has to be now before the honorable single judges.
And why this person is angry against the private respondent?
I'm sorry.
Why he is angry against the private respondent?
No, I have a specific case. Whether the private respondent, the certificate obtained by the private respondent as OBC, whether it is just and proper or not. As simple as this.
All right. What is he going to do? 8th respondent is Rehana Kautan Halsana. What is her age? 60 years.
I have got the news that by producing this document, they have contested the election as an OBC candidate.
Cat is out of the bag.
Yes.
By this,
I will go to the appellate authority.
Halsana is serial number 62 of the OBC list. He has the list.
The learned advocate for the appellant, writ petitioner, after some arguments, sought permission to withdraw this writ petition and exhaust the appeal remedy provided as against the OBC certificate granted to the private respondent. The writ petition is dismissed as withdrawn with the aforementioned liberty. Thank you. Next.
Serial number 22.
Wait.
22.
Yes, my lordship, I'm for the petitioner. Pardon. Lordship, I'm for the petitioner. Matter is regarding the illegal mining and sand lifting, my lordship. The petitioner is a permanent resident of Parvelia Bazaar, situated.
Who's doing the illegal mining? Which respondent?
My lordship,
what is this order sheet? Order passed by BDO?
The BDO.
Sorry, not.
Various RTI has been made and BLRO has informed us with that no ghat has been given for lease.
Then?
But still illegal mining and sand lifting has.
How do you say it is illegal? Where is the allegation? Where is your representation?
See my lordship, page number Page number 36, annexure P3, there are fake challenge has been made due to which the trucks has been released and throughout the West Bengal they are moving freely with loaded.
Madam, the BLLRO has said that at present no sand guard has been given on lease for sand lifting under the jurisdiction of BLLROs also. The undersigned would not be able to comment on the said point as this specific information doesn't fall within the purview. That is the reply given. You filed an appeal before the appellate authority. He confirmed that order. Now, if your case is, despite no permission being granted, somebody is doing the illegal mining. Is it your case?
Yes, my lordship.
Who's doing the illegal mining? Which respondent? You show the cost title. Sir, who is the state you are appearing? No, we can't make a roving inquiry, no? See?
But various cases has been registered by government of West Bengal as well as CBI and CBI and CID also, my lordship.
In Purulia district.
Yes, my lordship.
Where is your last representation?
My lordship,
Sir, the allegation is in Purulia district, without even any grant of mining grant permission, illegal mining is going on. And several newspaper reports are also there, but she has not implemented the alleged
persons involved.
Challans are nowhere. And it is basically, they say, illegal smuggling of sand. Huge amount of sand lifting by installing machinery illegally without any valid challan, and the sand has been transported using dumper tractor with overload to various sand mafias. Vigilance commissioner, what he will do?
He has no role to play. Only the district land and non-reforms officer is the authority who can check.
No, he has given in the RTA that no permission has been granted.
That is with regard to permission granted or not. But if any illegal mining is...
He has to consider, no? Where is the representation, madam?
Annexure P4, my lordship.
The petitioner, by way of this petition styled as a public interest litigation, states that illegal sand mining is going on, where no permission has been granted by the state authorities, and huge mining equipments are used, and overloaded trucks and tractors are transporting the sand, and the entire matter is monitored by sand mafias. The petitioner sought for information under the Right to Information Act, and the Block Land and Land Reforms Officer had informed by reply dated 1/9/2023 that that no sand guard has been given on lease for sand lifting under the jurisdiction of BL and LRO Uturia Against the said order, an appeal was preferred by the petitioner before the appellate authority, which was dismissed. The allegation of the petitioner appears to be that without any permission, the illegal sand mining is taking place. Certain newspaper clippings have also been appended to the writ petition, as well as copies of representations sent to various authorities. Since the representation has to be given to the appropriate authority, we direct the petitioner to give an appropriate comprehensive representation to the third respondent, namely the District Magistrate Bankura, by appearing personally in the office of the District Magistrate and enclose copies of the earlier representation as well as the
copy of the writ petition.
I think we have passed some order.
She will also supply a copy of the writ petition enabling.
Along with a copy of this order and the copy of the writ petition, after which the district magistrate shall take action.
District Land Reform Officer.
District magistrate will take action in accordance with law.
Much
Next.
obliged.
Lord, I am not appearing in that.
No, we will appear. So also appear.
Serial number 23.
Appear and
For the private respondent.
Please.
23, I am for the petition. It's a specific twofold allegations by around 124 villagers in their representation that the private respondents have constructed and are constructing in the process residential premises by completely blocking a government road, public road, which leads from the main road to a drainage canal. Well, this is the first part of the allegation. The second part of the allegation is that the private respondents have completely blocked a drainage canal and illegally conducting prawn farming in the drainage canal. Even the Honorable Chief Minister has time and again directed the authorities to clamp down on illegal prawn farming and pisciculture. Nobody cares. There was a Times of India reporting, if Lordship kindly turns to page 26 for once, this was reported in Times of India Bhubaneswar edition. This is basically what is happening. And this is a fact.
Yes, sir.
Lordship, so far as the plot numbers mentioned by the petition is concerned, it's wrong. He is alleging, my lord, this plot number on which shrimp this farming is going on. He says it is 2161 and 1738. But as per the, may I respectfully hand over the copy of the report? ADMLR has given report. May I respectfully hand over this copy, Lordship? Lordship kindly takes the second page onwards. First page is OTS. Kindly sees para 1, he says it should not be 2161. In para 2, he says it should instead be read as 1838 by 2161. Lordship, go to second page, second paragraph.
As primary content of instrument regarding encroachment, it's
Yes.
stated.
It should be not 2161 only, it should be 1838, which is fully vested.
So you take action.
Lordship.
May I submit one thing? The construction which has been alleged to be already been constructed by my client, the private respondent. That is the 1841. Where is my house is concerned, my God. So for the 2161 and 1738, we are not concerned.
Okay,
And
then
it has
don't
been
worry.
shown as if my house was constructed on those as an unauthorized construction. And now there is a suit is pending. Main problem is and difference of opinion. Is a suit is pending. We have already approached for the tribunal also, and they are everywhere they have lost.
But a person will construct his house on government land by blocking common pathway.
I have given and reply
And the
to
court will grant injunction.
the first reply to the question is regarding shrimp. Second, melody encroachment of public pathway. Kindly have a look at paragraph 3 of the report. It says encroachment to some extent is observed in the suit plot. Kindly see the last sentence, clause paragraph 3.
Some extent.
To in the suit plot. So these are the two answers, which this ADMLR.
All right. By this public
given.
interest litigation, the petitioner alleges that the private respondents have blocked a village pathway in RS DAG number 2161 and 1738 of Uttar Sonakali village. There is another allegation that the private respondents are illegally conducting prawn farming over a drainage canal. In this regard, representations were given. And since no action was initiated, the petitioner has filed the present petition. The learned government, Mr. Galib, learned government council has produced the written instructions given by the additional director and block land and land reforms officer, Basanti, not 24 Parganas.
South 24.
Sorry, South 24 Parganas. wherein it has been stated as follows, sir. Quote this, sir. From here to here. Thus, it appears that there is a variation in the plot numbers. And apart from that, the report also says that there is encroachment to some extent observed in the suit plot. The learned advocate for the private respondent submits that a suit is pending between the parties, and there is also other matters pending before the tribunal. However, in the light of the report submitted by the additional AD and BLLRO,
Not ADMA, he is BLLRO.
BLLRO, we direct the said authority to conduct an inquiry into the matter after notice to the petitioner and the private respondents, and also after directing conducting a fresh inspection in the presence of the parties, and proceed to take action in accordance with law.
On prior notice, man.
Obviously, as expeditiously as possible.
My lord, the state may be directed to hand me over a copy of the report, my lord. Isn't it? Fresh and
I will give my next.
Serial number 24.
The affidavit of service may be kept with it.
Pomito Mandal. Yes, sir.
Mr. Arup Kumar Bhomik is the AOR of this case. He could not come today, so I am paying for a not today.
Better. There are twofold, my lord.
Allegation of misappropriation.
Yes, my lord. There are twofold grievance. My lord, the member of the, my lord, the Panchayat, one of the Panchayat member, my lord, alleged that she refused to sign on some papers or documents that was proceeded to for the purpose of issuing tender document. She refused. And for that, my lord, she suffered from, my lord, several, my lord, intimidation and also molestation and other. Now, my lord, the two complaints lodged with the two different police stations on two different dates. Now, the two police stations report are here. My lord, in both the occasions, my lord, the FIR lodged and my lord, the accused person. Oh, sorry. Sorry. Now, in both the occasions, my lord, in terms of the, my lord, the FIR, my lord, the accused persons, my lord, one of the accused persons arrested, others obtained bail. My lord, the first page and second page is the report of one of the police station, Manikchok. And my lord, the third page is the in respect of another, my lord, the complaint lodged in by the with the other police station, and my lord, the report submitted to the superintendent of police. Now, in both the occasions, my lord, the investigations are pending because the matter relates to, my lord, November 2024, and the other is of, my lord, December 2024. Now, my lord, the FIR lost, my lord, and they obtained.
No, that is on the criminal language.
Criminal. Now, my lord, so far,
here in the writ petition, they say.
Yes. So far, the embezzlement of the public money.
Yes.
And or misappropriation of public money. And with regard to that, so far, the complaint to the block development officer is concerned. My lord, interacted with the block development officer concerned, and my lord, my humble submission that, my lord, I have been requested to make submission that a few days, so if it given, then, my lord, whether if any steps have been taken or not, or that I can place before your lordship.
At the request of next week, same position.
And my lord, kindly record that the police report I have.
And the report submitted by the respondent police has taken on record.
Fine.
Next.
Serial number 25.
85 for the petitioner. This is the public interest litigation. The allegation that, my lord, the private respondents has, my lord, the constructed upon, my lord, filling of the water body. My lord, kindly see the
Initiate demolition proceedings and the Inland Fisheries Act.
Yes, my lord. Kindly see the, my lord, the photographs. My lord, the petitioners has, my lord, has come before this court, my lord, by way of public.
Who's the petitioner?
My lord.
Petitioner is the Pradhan of the Panchayat.
No. Petitioner of the Panchayat, Pradhan has, my lord, wrote a letter to the, my lord, concerned authority that there are, my lord, illegal construction to my lord, take action. Despite that, my lord, the local persons, my lord, the villagers have also, my lord, made a joint application.
But petitioner is the one of the candidate who is the social activist. He has come before this court. Kindly see the pictures. The private respondents are the person responsible has been making construction. Kindly see the.
And what happened to your complaint? Whether any inquiry was conducted?
No, nothing. But the Pradhan of the concerned Gram Panchayat has wrote a letter to the concerned block development officer. IC kindly take steps to stop the unauthorized construction over the water body. Despite that, no action has been taken.
So far, the police authority is concerned, my lord, on the basis of the complaint, my lord, the FIR lodged and my lord, subsequently, my lord, the charge sheet has also been filed. Lordship, kindly have a look, my lord, the third paragraph of the report and my lord, the next paragraph.
Yes. Now probably, if it is found that there is illegal construction, he will plead guilty and pay the fine.
My lord, yes.
You are for the private respondent.
Yes, your lordship, may I permit it? I'm just representing private respondent number 13 to 18. Now, your lordship, it is their admitted case in the writ petition. The cause started, paragraph 3. In the year 2022, since 2022, the private respondents have been harassing Gofran Mullah with the intention to grab the said plot of land. This is the starting of the dispute that is not related with the public interest litigation.
No.
Now, let me finish.
Who is this Gofran Mullah?
Somebody else.
Private respondent
one
number.
of the.
Now, your lordship, this will be clear from their representations. Running page number 18. What is the allegation against only one private respondent here? Bohudin purbe ukto. Since long, there are few shops at the side of this pond. This private respondent number 14 to 18 are the owner of that shops, those shops. Since last 30 years, we have all the documents, electricity bill and everything. We are there. Now they have the private dispute with private respondent number 13 only. They might have, this private respondent number 13 have started some renovation in his shop. That is the problem. Now they are claiming a right, they are claiming a main prayer against the fisheries authorities. Now, strangely, your lordship.
Fisheries authorities, because if it is a water
body, they have to take
Yes,
action.
water body. But no representation.
Of the shops are made and they are running.
No representation.
If the shop is on the road margin,
yes,
or adjoining the water body, without a title or without any right over the immovable property, you could not have constructed.
We have all the title documents, your lordship. I have.
Let the authority inquire. You produce it.
Yes,
matter is over.
and one thing, this
And one of the point.
kindly place this order after filing of this writ petition. This authority, BLRO authority, have passed this order to revert back the land in its original position. How can it be when I am there since last 30 years? They have to inquire.
Challenge this order.
Yes, yeah, I will. And they have to ascertain 1 minute. They have to ascertain first whether I am there since last 30 years, whether it was done 30 years back or not.
That the private respondents have encroached and constructed in a water body and pray for action under the West Bengal Inland Fisheries Act. It is the learned advocate for the private respondent has produced before us a memo issued by the Assistant Director and Block Land and Land Reforms Officer, Vishnupur 1, dated 16/1/2025, wherein the BLLRO has directed the private respondents to remove the structures from the Doba at their cost and restore the Doba to its original form by 15 days positively, failing which legal action will be initiated. Thus, the representation given by the petitioner has been acted upon. If
My lord, I have not received any notice and my lord order.
Not required. And it is a very old construction, sir.
No, my lord, this is the new construction.
The petitioner has been acted upon. Therefore, we leave it open to the Block Land and Land Reforms Officer to proceed in accordance with law, and it was open to the private respondents to canvass all issues before the authority. Next.
Gratefully, Your Lordship.
Not affidavit of service.
Affidavit of service kept on record. Police report kept on record. Next.
Serial number 26.
My lord, I appear for the Fisheries State Fisheries Development Corporation, Your Lordship. Lordship, it is a public interest litigation. My lord, the grievance of the petitioner, my lord, has already been redressed. My lord, the petitioner wanted to know that there was a fishing harbor which was supposed to be instituted at the Namkhana district, Your Lordship, and the State Fisheries Development Corporation, my lord.
Election matter?
It's election matter. I tell
Election,
you.
I appear
You
for
are
the
wrong.
co-party
No,
election
she is going to
commission.
withdraw the writ petition. This is election matter.
Oh, Lordship, again, I'm sorry.
My lord, in view of the.
Lordship, I'm.
My lord, your lordship.
So the election is
Lordship, I
over,
am praying
Lordship.
for
It's a
not
matter
to
related to, my lord,
Sorry.
co-party election.
In terms of
It's a
section
matter of, my lord,
35, my lord, rules have been framed.
no, it is not
All-
required because one, my lord, one party filed a case, my lord, for holding the election. Now,
Committee.
this petition, my lord, says there is some irregularity, let the election be stopped. Now, my lord, in the meantime, 31st, my lord, of January, election has been conducted. Election is over.
And in terms
I
of
do not
this-
know who is appearing
in
for the
terms of
petitioner.
dispute, my lord, all dispute to be settled by.
No,
election.
question of dispute is not, my
No,
lord,
no,
is
I'm
arising
No,
at
if
all.
there is a dispute, there is a remedy is what
Yes, yes, what my lord is going to say. But who is petitioner?
the petitioner by way of this public interest litigation seeks for a direction to correct the voters list and include 125 members of the Bill Wagram branch, and also for a direction to conduct a fresh election based on the corrected voter list. The election was notified on 13th April 2012.
My lord, 30 election is over, my lord, on 31st. On, my lord, 31st January.
The election was notified, not 12, was notified, and election has been completed on 31st January 2025. In any event, once the election process has commenced, the question of interdicting the same by way of a writ petition under Article 226 of the Constitution is not maintainable. Apart from that, the relief sought for by the writ petitioner to correct the voters list, that too by way of a public interest litigation, is also not maintainable. Therefore, no relief can be granted to the petitioner as prayed for. Dismissed. Next.
Grateful.
Serial number 27.
27.
I am for the same. I appear for respondent number 5.
What
This
is
is absolutely not maintenance, my lord. As of now, this public interest litigation is not maintenance, my lord.
What is the prayer they want?
My lord, they have filed a suit. He's trying to
take possession of the property.
Yes, my lord.
The petitioner is the tenant. And the tenant is challenging my title.
In the writ petition.
Yes, my lord. And that too, my lord, the old GA in file before the
They have
honorable.
filed one eviction suit that 7172 is rejected, and in the verge of when struck out, they have filed this petition.
But he's saying some donated land, RG car, etc.
But there was a will, that will was subsequently, codicil was executed. But they have no knowledge about that codicil.
The petitioner, by way of this writ petition, seeks for direction to take possession of the property in question as per the order passed by in GA number 1165 of 2004 within bracket TS number 2 of 1963 / PLA number 109 of 1962 dated 10/6/2004. On going through the papers annexed to the writ petition as well as the prayer sought for, the question of enforcing a order passed in a testamentary proceedings by way of a writ petition, that too by way of a public interest litigation, is not maintainable. Hence, the writ petition is dismissed. However, it will be open to the concerned persons to invoke the appropriate remedy in accordance with law. Next.
Serial number 28.
But I appear on behalf of the petition.
My lord, I
Here, my lord,
Grievance, you said grievance redress.
Yes,
No, no, my lord, according to me, my lord, that is not. Lordship's kindly say, my lord, no copy has been given. Why he is saying, why he is saying, I do not know.
Well, I'll show it before your
Actually,
lordship.
Lord, in 2012, 2013, my lord,
Construction of
budget
marine
session-
fishing harbour at Haripur.
Yes.
Yes.
Under so and so. Commanding each of the men to utilize sanction grant 157 crore.
Yes.
Declared for implementation of the project.
Yes.
Who gave 159 crores?
But
Where
this is the budget place, Government of West Bengal sanction in 2012, 2013. Lordships kindly come page 37. In 37, e-tender notice has been issued. There are two work, number 1 and number 2. I am concerned with the number 2. The preparations of details project report, including survey, soil design for construction of mini fishing harbour center, minor fishing harbour at Horipur. I am at Horipur. The amount has been sanctioned 1,57,007 crore. Now here 40 crore has been mentioned. Now nothing has been done. We made a representation all the villagers, page 51. Lordships kindly direct the district magistrate to take a decision or in considering all aspects.
Now,
2 points are there. My
State
lord.
Fisheries Department invited this tender.
Yes.
Whether the tender was finalized?
Yes, your lordship.
Ah.
Lordship, the tender has been finalized. My lord, in respect to the my lord work which is at number 1, my lord, e-tender was floated and my lord tenders have been given to the parties.
No, number 2.
And my lord, number 2 also, my lord, it has been done. I have got the instruction in respect to number 1, my lord. Number 2, I am instructed that it has also, the same has been done in respect of number 2. Lordship, I'm sorry.
But then what is the stage of the tender?
Yes.
My lord, the tender has been given. The work is supposed to commence, my lord, from 7th of January. That is what I was instructed.
So this is
Work
for
order, my learned friend, the work order also has been.
Yes, your lordship, work order has been issued.
no, this is for project. What saying that is the preparation of detailed project report. How the project is to be completed. This is only for 40 crore. For preparation, the I-1 for establishment for construction of the construction of the fishing harbour. This was started similar to the commencing from 2010. There is a
No, you see, there are several documents.
Yes.
First document is construction of different buildings in connection with the work of construction of fishing harbour. Second is construction of jetty in connection of the fishing harbour. Then third is construction of dry dock, electrical work. All your work order has been issued. Mitro and Company, drill technology, survey work.
Lord, may I pray one thing? Let us give a copy to us. Lord, we shall consider. We shall come back next.
No, we will direct them to proceed further. Your concern is the construction should be complete at the earliest.
Yes.
Now they have issued work order. Let them proceed. Probably it may take about 1 year or 2 years.
Whatever may be. The people are wanting, my Lord. Lord, only my respectful submission is this.
The petitioner's concern is that though a substantial amount of funds were sanctioned for construction of a fishing harbour, the same has not been, nothing has been done pursuant to the notification, e-tender notification issued by the State Fisheries Development Corporation Limited, dated 8/5/2023. The learned advocate appearing for the respondent submitted that the apprehension of the petitioner is not well founded, as pursuant to the e-tender, work orders have been issued to various parties for different nature of work in respect of both items of work as mentioned in the e-tender notification issued by the State Fisheries Development Corporation. In respect of one of the works, the various work orders issued on in December 2024 has been placed before this court, which prime facie show that the matter that that work is that the matter is under progress.
Yes,
nonetheless, the authorities should ensure timely completion of the project so that the public will be not put to inconvenience. It is true that the project will be time consuming, but the State Fisheries Development Corporation should closely monitor the progress of the work and ensure early completion of the
The amount of rupees, the amount has been sanctioned, page 19 is reporting in the newspaper, one of the 157 crore. Here, my lord, it has been reduced to 40 crore.
Let us
Let them, my lord, intimate their decision, their document of the progress.
Grateful.
Okay.
Well,
Yes, yes.
well, let a
Next.
copy of the, my lord, the
Serial number 29.
Prana, you give a copy of the report.
yes, but I.
No scope of interim order only, my lord. I want to file, my lord. This one can file, my lord, affidavit, my lord.
What affidavit?
Because, my lord, the protection, prayer for, my lord, protection for the, my lord, minority in the border area throughout West Bengal, my lord. This is a, my lord,
This is a
serious question, my lord.
This is a political issue.
No, my lord, not political,
no,
this is
no.
social, my lord. Because, my lord, their border area, my lord, highly affected on the, my lord, on the issue of, my lord, this, my lord, political.
Trans-border migration,
Yes, my lord.
moving from one country to another
Yes, my lord.
without proper valid documents,
Yes,
travel documents or travel authentication
Yes, my lord.
is illegal.
That is not
We
my
cannot
prayer,
issue,
my lord.
we
Prayer
cannot
is, my lord,
issue the mandamus to another country.
not
Well,
country, my
yeah,
lord.
another-
Border area, my lord. Border area throughout West Bengal, my lord. My prayer, my lord.
You cannot issue a mandamus which will in effect benefit a non-citizen.
Not non-citizen, my lord. Border area citizen people.
They are coming, sir.
My lord, Central can
They
give,
are
my lord,
coming.
affidavit, my lord.
BSF is under fire now.
No, my lord.
Already,
This is
yes.
the high question of, my lord, law and order situation also, my lord. Because, my lord, every day, my lord, there are.
When we meet elsewhere in the.
But because, my lord, BSF
I will
Act
tell
totally
you-
saying that 70 kilometer people are under BSF control, my lord. As far as law and order situation control, my lord. Central can give affidavit for the period of protection. That is, my lord, that you know, yes, that is true. But Central can give, my lord, some affidavit regarding this, my lord, response, my lord. That is my prayer, my lord. Yes, that is true, my lord. But kindly, my lord, some clarification, my your lordship, kindly some clarification by the, my lord, central authority, my lord. Only, my lord, my prayer, my lord. Kindly protect, my lord. Kindly দেবে না।
আগেই তো আমি বললাম হবে
চাইছিলাম
আনলিগাল মাইগ্রেন্টস তো